Good morning, everyone. We are delighted to see all of you here gathered today for oral argument. We are going to begin with our first case of the morning, appeal number 24-1522, United States versus Walker. We have Mr. Schultz is remote, and do we have Ms. Archie? Oh, ready, okay. When you're ready, Mr. Schultz.
May it please the court, counsel for the government, Todd Schultz, Assistant Federal Public Defender, representing defendant, appellant Richard Walker. District Court in this case erred in denying defendant's motion to suppress evidence which was obtained during a warrantless search of a trailer where he was an overnight guest. The two warrantless searches of defendant's son's bedroom exceed the permissible scope of a protective sweep under Bowie. The homeowner's later consent to a third warrantless search was tainted by and the product of these earlier illegal searches. In Maryland versus Bowie, the Supreme Court recognized two types of protective sweeps. First allows officers to look in closets and other spaces immediately adjoining the place of arrest from which an attack could be immediately launched. It requires no
Question, should we first deal with whether or not we have standing to go down this path, seeing that the argument was raised that there's no privacy interest?
Your Honor, I'm happy to address that. Your Honor, overnight guests unquestionably have standing to dispute a search at the residence they're staying at. This is well-established black letter law. The United States Supreme Court has made that clear in Minnesota versus Olson. That case, I think the court essentially says an overnight guest has standing to challenge a search. We need say no more. So I was surprised that this is an issue of dispute between the parties. I had known there would be a number of things that we would disagree about, but this is black letter law. And I would just point in the government dispute in its brief disputing standing, it does not mention the dispositive case. It does not cite to Minnesota versus Olson. And so I don't see this, although the government raises it in its brief, I don't see it as being an issue. I see it as being very clear cut that the Supreme Court has said individuals like the defendant who are overnight guests have standing.
Mr. Schultz, do you want to respond to the government's argument that essentially there should be a carve-out and that we should establish a carve-out for someone who's under court supervision who may or may not be in violation or who may be in violation of those supervision requirements?
Your Honor, I don't think that the Supreme Court's ruling on this could be any clearer. The Supreme Court says that it's enough that the person is an overnight guest. I think the cases, one in particular that the government references involves a domestic situation where the person is specifically excluded from the address to be searched. That's not the circumstance here. And I don't know, Your Honor, because the record is extremely limited, whether in fact Mr. Walker was prohibited from staying at the address where the search was undertaken. I know that wasn't the primary residence. I don't believe it was, but I also don't know that that location would have been prohibited based on the evidence in the court, in the record that's before the court.
Counsel, there was a pretrial condition, pretrial release condition that he was on home incarceration at his mother's house, correct?
Your Honor, I know that the government argues that, and looking through the record, preparing for this, I don't know that that's in the record. If I'm mistaken on that point, it would not change my position that he's not prohibited, although he would be required to stay at a certain address. He has, pursuant to Minnesota versus Olson, this expectation of privacy where he sleeps.
Mr. Schultz, excuse me, did you request an evidentiary hearing on this motion to suppress?
Your Honor, I did not, and as the case has been pending, I've gone back and forth as to whether that tactical decision was a wise one. I guess maybe because I'm arguing today, I've come down on the side that it was. The reason that I think it was a wise decision is because the government bears the burden in the context of a warrantless search as with respect to a buoy sweep to point to specific articulable facts that justify the search. And by limiting the record to only the two officers' reports, Officer Blackburn and Agent Green, I believe that benefits the analysis for the defendant because, as the court knows, there are no specific facts in either of those reports about the residents or what they saw there that would warrant them lifting up a mattress and looking between a mattress and a box spring. So I thought about that issue.
On this question of standing, though, because you didn't file a reply, isn't this waived, the path that we're headed down?
Because I didn't file a reply to what?
You didn't file a reply at all, correct?
In front of this court, Your Honor?
Yes.
That's correct. What issue is it that the court believes I have waived?
That's what I was on the question of that was raised regarding standing. The notion being that the government has now misinterpreted the case in regards to privacy rights of an overnight guest.
Right, Your Honor. I did not file a response to that because well-established Supreme Court law says that that's not the law. And so to me, it appears I may be mistaken, but it seems to me Minnesota versus Olson would trump a argument made by the government and rejected by the district court. And so I didn't spend much time in my brief because I am confident that as a matter of law, the Supreme Court has the last say on this. And the Supreme Court has said, no limitations. If you're an overnight guest, that's enough. It doesn't say if you're a certain type of overnight guest or have any kind of cutouts. The Supreme Court simply indicates in Minnesota versus Olson that in fact the individual has standing as an overnight guest. I'd like to, if it's permissible, I'd like to address the buoy sweep argument and the searches, which are at the heart of, I believe to be at the heart of this appeal. This case does not involve the first type of buoy sweep that does not require probable cause or reasonable suspicion. This case involves the search of an interior room in the trailer. Common sense tells us, and we know, that it's not immediately accessible to an arrest that occurs outside. Because this is not an immediately adjacent area, the search isn't automatic. They don't get to walk through the entire house in circumstances like this. They must show articulable facts which, taken together with rational inferences from those facts, would warrant a reasonably prudent officer in believing that the area to be swept harbors individuals posing a danger to those on the arrest scene. It's not a full search of the premise, and it extends only to a cursory inspection of spaces where a person may be found. I think importantly for this case, the second type of buoy sweep is not an occupancy check. Police don't get to perform a sweep just because they think someone might be inside. They need to have specific and articulable facts that would indicate someone is inside, not just that there might be. Because if it's otherwise, there could always be one more person in a house. And so what would then happen is the second buoy sweep would go away. It would become automatic that they could always go inside again, because who knows? There could always be one more person in the home that's unaccounted
Counsel, I
for.
want to make sure I understand what you're classifying as the first and the second protective sweep.
Yes, Your Honor. The first sweep, which is not an issue in this case, is a sweep that requires no reasonable suspicion and is automatic. It extends to places immediately adjacent to the place of arrest. This is an arrest that occurred outside. We're not certain on where it occurred outside, but we know it occurred outside. So there's no way in which this interior room, a bedroom, could be deemed to be immediately adjacent. I believe Agent Blackburn's
So I just want to make
report.
sure I'm following your argument. The contention is there was not a search incident to an arrest on the outside. Once you went into the house, it's elevated now to a protective suite.
Right. And Your Honor, what I'm suggesting is that they don't have, it's not automatic that they get to go in. And it's even, I should say, it's not automatic that they can go beyond immediately adjacent areas. And in this case, they go into the interior of the home and they reference no specific facts that would justify them in thinking that there was another individual present or that that individual posed some kind of danger.
What do we
And
do
so I'm
with
saying,
Walker
as a
Jr.?
practical
I'm
matter,
sorry.
they don't even get to go into the bedroom.
I'm sorry.
And then beyond that, in lifting up the mattress and looking between it and the box spring, they're clearly not engaged in a buoy sweep because it is not physically possible for a human being to hide between a mattress and a box spring. And what I think is probably the best evidence on this point that they weren't in fact looking for a human being is the photos themselves. The photos in this case clearly
What do you do
show
with
you
Walker
could-
Jr.'s statements, though? Before you get to the bedroom.
that he doesn't know who else is in the house?
Yes.
Yeah, so what I'm suggesting to you, Your Honor, is the simple fact that there might be someone in the house is not enough. And it's my belief, Your Honor, and in my experience, officers don't rely on what people say coming out of a home. The way it works practically and the way it worked in this case is they go in. And, you know, there's no reason to think that law-abiding citizens in a home, and all indications are that the occupants of this home were law-abiding, with exception of the man who was in custody, that those were law-abiding individuals. And so it's a real jump in my mind to suggest that somehow law-abiding citizens who actually, of course, as we now know, weren't home, that they pose some kind of risk. It's not enough to say someone might be home, so we get to search the whole house. Your Honors, I realize that I'm into my rebuttal time, so I would like to reserve the remainder of my argument for rebuttal.
Very well, Mr. Schultz, thank you. We welcome Ms. Archie to the podium. And you can correct my pronunciation when you arrive.
May it please the court? Good morning, Your Honors. My name is Kim Archie, and I represent the government appellee in this case. As a threshold matter, this court should deny the defendant Richard Walker's appeal and affirm the decision of the district court because Richard Walker did not have a reasonable expectation of privacy in the residence, and the court should reject his Fourth Amendment claims to suppress both the firearm and the drug evidence in this case. Although...
Ms. Archie, I have a question,
Yes.
and the same one that I posed to your opponent, which is the pretrial release conditions. Are they in the record?
They are in the record in the sense that the defendant acknowledged them in his interview. The officers were aware of them and incorporated them in their reports. The actual pretrial release order from the county judge that included those conditions are not included in the record, but the defendant conceded in his interview with police that he was on pretrial release. He was supposed to be residing with his mother at a different residence in a different city, and he was not permitted to leave that home as he was on house arrest. So that is the way that that pretrial condition is in the record. The court should find that although Richard Walker was an overnight guest, he had no legitimate expectation of privacy in that he was there in violation of the court order, and to grant that Richard Walker has standing in this appeal, he would be rewarded with more expansive Fourth Amendment rights by the nature of violating a court order than he would be if he were in compliance with a court order. if he were in compliance with the court order. He should not have been present at that residence and should not have
Ms. Archer,
privacy.
why would this be the case for us to expand the Supreme Court's overnight guest jurisprudence in that direction, where we have a situation where the record is, you're asking us to draw these kind of inferences from the record, and where there was no evidentiary hearing and the district court did not pass on all of this below? Why is this the case to push where you would like us to push?
Although the court order is not in the record, I think the record is substantial for this court to make this finding because it's not disputed. The defendant himself said in his interview that he was on house arrest and he was on these conditions. So I think this record is sufficient to make that finding because there is no dispute. Although that order is missing from the record and although that there was no evidentiary hearing, there was no evidentiary hearing because there was no disputed fact at the time that we were filing the motions. And so because there was no disputed facts at the time we were filing the motions, the evidentiary hearing wasn't necessary.
Two things on this issue of standing. Did we raise this below in regards to the bedroom and I guess Walker Jr.'s bedroom and Paulette's bedroom, or was standing limited to only Paulette's bedroom? How did it work below?
Below, the government raised the argument that the defendant was excluded from asserting a privacy right to his son's bedroom and the household as a whole. The government did not address Paulette's bedroom specifically in the district court, but it is incorporated within the argument that he has no privacy right to the home. If there are no other questions on the expectation of privacy, if the court reaches the question of the constitutionality of the
I guess I do have one follow-up question. The cases that the government cites to, it's pretty focused on cases where you or the individual was legally not permitted to be there. And so going to just Judge Jackson-Huey's question, is this stretching it a little bit further when we have Shipp, who has not contested Walker's legal right to be in the premise? And so the eviction cases, it was illegal for you to be there. And so just wanted to kind of flush that out a little bit more.
Sure. The best analogy for this situation are the civil orders of protection cases. And in those cases, although a defendant in that circumstance was specifically excluded from a certain home, the consent of the petitioner in the order of protection had no bearing on whether the court found that the privacy right attached or did not. So the consent of the homeowner does not override the court order from that line of cases. And I think that analogy can be applied here as well. All right, if the court does reach the question of the constitutionality of the sweep, the court should affirm the district court's finding that the protective sweep was constitutional. The protective sweep into the residence after Walker's arrest was necessary to ensure the safety of the agents involved because 2 residents of the home were unaccounted for. These are not purely speculative. At this point, when the officers went to the home, they knew that these 2 other individuals resided there. They knew that these 2 individuals had not presented themselves to the officers when they arrived at the scene.
Can you point us to any cases that say, as long as someone else could be home, a possibility, okay, not a specific and articulable fact that they might certainly be in, there, that officers can go in? And also, can you point us to any cases where someone's arrested outside and police decide they need to go inside to conduct a protective sweep?
Your Honor, I'll take your second part of the question first. As far as the assertion that the defendant was arrested outside of the home, it is a little bit more nuanced in that he was arrested right at the threshold to the home, right at the front door. The front door of the home was open. They observed Walker after some time, after many call-outs, after repeated asks for him to come to the front door. They observed him walk to the front door from that hallway and then present himself for arrest. He was not arrested fully outside the home. He was arrested right at the threshold to the home, and the officers observed him coming to the door. And as far as the first part of your question, I cannot think of a specific case that just says the possibility of presence, but the line of cases all say as long as there is a reasonable and a specific articulable fact that and reasonable inferences that can be taken from those facts, which I think is an important thing that the appellant has ignored in this argument, is that it's not just the specific facts articulated by the officers, it's also all those reasonable inferences that law enforcement take that can come into their analysis.
But take Mr. Schultz's point that someone can always be home. Someone extra can always be home. And you look at our case in Tapia. There, the arrestee was arrested, as best we can tell from the opinion, in the threshold, okay? At the threshold of the home. The police noticed a Lincoln Navigator that they had not noticed before outside, and they knew that one of Mr. Tapia's associates, a fellow gang member, owned a Lincoln Navigator. That's what they asserted as articulable specific facts that they then needed to pass the threshold and go into the home to look for this potentially associate gang member who was an individual who could pose a risk. Here, by contrast, we have people who the police know that two other people, as Mr. Schultz is saying, for all they know, are law-abiding people who also live in a home, because you know what? Homes contain multiple people at times. Can you address his argument on that and the distinction with Tapia?
Yes, Your Honor. I think the court needs to look no further than Maryland v. Bowie to answer this question. In that case, the court found that earlier in the day, a police employee had called Bowie's residence and spoken to a woman. And when they arrived at the residence to execute the arrest warrant, the woman did not present herself. And so that was part of the specific and articulable facts that the court took into consideration when analyzing whether the protective sweep was justified. There was no information in that record that that woman was not law-abiding, just that she was merely present at the home earlier in the day. I'd like to address the further specific articulable facts because they're not just limited to the presence of the residents who weren't already home. The officers were also aware of the pending charges that Mr. Walker had absconded from St. Clair County Court from. This was unlawful possession of firearm ammunition by a felon. I think one of the reasonable inferences from that charge is that ammunition goes into a firearm, and it was very possible that Mr. Walker was in possession of ammunition because he also had a firearm. And so having...
Counsel, I'm going to have to stop you there. That's a little bit of a stretch to suggest that ammunition alone, without there being attached to a firearm, poses a risk that justifies going in for safety purposes. That's the purpose of a protective sweep, something that can put the officers at risk. And so I want to really direct our attention not to, if we can, move beyond that to tell me what allowed those officers during a protective sweep, if we accept the argument, to lift that mattress. What are those facts?
Yes, Your Honor. The officers, the two reports that are submitted to the court and in the record, both officers from different law enforcement agencies stated that in their training and in their experience, People who are trying to hide themselves from law enforcement do hide in unexpected places. Each of them noted in their reports that they had experience with people hiding underneath mattresses, in clothing dryers, in all kinds of places you would not expect to find a person. So the district court relied on those officers' assertions in their report. The district court found those credible and found that that was sufficient in order to lift the mattress.
One difficulty we have here is there's a photo in the record. And the photo shows us this mattress that they lifted, and it's above the box screen, okay? And so we have to judge the reasonableness of the officers looking at that exposed mattress. There was no comforter over it or cover or anything, and the government has not said that this photo does not represent the scene as the officers saw it. So we have to judge the reasonableness of looking at that exposed mattress on top of that exposed box spring and lifting it up thinking that there's a person in between the two items.
Your Honor, to that point, I would just say that the district court reviewed this and made the finding, and it's a factual finding, that a person could hide between the mattress and the box spring, and that is only for clear air review by this court. And the district court did not clearly err in making that finding, and so—
What did it base it on? What facts?
The district court had the photographs available to him, and so the district court reviewed those photographs along with the reports provided, the agents' assertions in their reports, their comments on their experience, their training, and found that it was a reasonable and logical conclusion that the officers would think it was necessary to look there for somebody
Unless
hiding.
we're looking for Flat Stanley, I'm still wondering what are the facts that support generally, yes. There's generally people can hide in a dryer. Generally, people can hide under a bed frame that's lifted up of a box frame, okay? What are the facts, though, that supported going from the generality that in the past people have hid there of the facts that supported someone was hiding between this box spring and mattress for the district court in this case?
I don't think there are any additional to what I've already provided the court and what the district court noted in its review of the evidence available in the record. Simply the district court was able to see the photos and able to review those same reports. And, until you lift a mattress off a box spring, you don't know whether it's hollowed out, whether there's a compartment, what's there. And so until an officer takes those steps to ensure their safety, there's really no way for them to know what may be lurking underneath a mattress.
I guess what are the contours of whether the protective sweep is now going beyond that, right? When you're lifting up mattresses, when you're going beyond without articulating the why. And so if we accept this is the rule or the standard, where is the line drawing for officers to know when the protective sweep has kind of gone beyond that of an articulable risk to safety?
I think the court doesn't really need to expand the current law that is available. As long as an officer has a reasonable and articulable and specific facts about the scenario, about their training, about their experience that describes why they do certain things during a protective sweep, and a court looks at those, a district court looks at those and finds those things credible, I don't think it requires any expansion of the current law into what is allowed in a protective sweep.
Ms. Archie, in your brief, you argue that the sweep was long over. I'm quoting from your brief, quote, was long over, end quote, by the time the homeowner arrived at the scene. Exactly how long had it been?
Your Honor, that's not clear from the record. We know from the officer's reports and the other information we have from the interviews on scene, that it was completed. All the protective sweep was completely over. Everybody was outside the residence by the time that the homeowners arrived home. I see that my time has run. If there are no other questions, I just ask the court to affirm. Thank you.
Thank you. And Mr. Schultz, you can have your full 4 minutes. We took Ms. Archie over.
Thank you, Your Honor. I appreciate that. Real quickly, I hope the court will take some time and relook at those photographs, because you could absolutely tell no one was hiding in that box spring, because that box spring, despite this is one point where the district court clearly erred, that box frame or that box spring is on has a frame underneath it. So they could have looked underneath the box spring without lifting the mattress, and that is clear from the photos. I'd like to real quickly, because we've spent all this time talking about the first warrantless search, I don't think it would be fair to my client not to briefly address the 2 other warrantless searches that took place. And so what I think this court could focus on is the second warrantless search of that bedroom. And that is done by Agent Green, and there is no buoy sweep involved. When Agent Green, without a warrant, lifts up that mattress, he's not looking for somebody under that mattress, he's looking for evidence. And so this court can just address that second search and say clearly there's no exception to what Agent Green did. The proper practice in that situation is to obtain a warrant. And the other thing I would point out, Your Honor, is if an individual during a buoy sweep sees a firearm in a residence, that firearm is not automatically seizable under the plain view doctrine, because firearms are not contraband per se. They don't have an immediately incriminating nature. In fact, millions of Americans legally possess the exact firearm in this case. And what the officers were required to do at that point was to seek a search warrant or consent to seize that firearm. I acknowledge.
If we accept, Mr. Schultz, that this was a violation, why would the exclusionary rule good faith not apply?
Well, I don't think that the good faith is the analysis that I think the court should apply. I think the analysis the court should apply for the gun, Your Honor, is the inevitable discovery. And you have
before
in
I
this
get there, I want to first have you answer my question. Why would the good faith exception not apply?
Your Honor, when I've seen the good faith exception apply, I've seen that apply in the context of applications for search warrants. I've not seen it apply to a warrantless search of a home, and certainly not one of this nature. What I would note, though, I wanted to just mention, Your Honor, real quickly, this court's, some dicta from this court in lists. One of the things I try to do when I have an argument before the court is if I can hopefully find another case from the court that is directly on point, that's extremely helpful for me. And so I just want to read this portion of lists, which this court decided, which addresses this specific situation. The court in that case was concerned exactly about the police practice that is routinely employed and was employed in this case. And in that case, the court said, quote, the police could, of course, exploit illegally obtained knowledge to coerce an individual into providing consent for another search. Such a danger would seem to loom larger where the illegal search and the subsequent consent search were of the same location. The defendant's consent, in that instance, the defendant's consent could be influenced by the belief that there is no reason to withhold consent because the officers had already searched the location, end quote. That is this case exactly. That's what the affiant, the person who consented, said happened. And so the gun should be suppressed. With respect to the additional evidence that was obtained, that should also be suppressed because consent was given immediately afterwards and of the same location.
Do you agree, though, that argument was forfeited?
No, Your Honor. No, that argument was made in the district court. That argument was raised, I think, in point 5 in our brief. And so all along we've sought
talking about the drugs. The drugs, is that what you're referencing?
Yes, ma'am. We've argued both in the district court and then I think it's like the final portion of our appellate brief that those would be suppressible, that the court should apply the attenuation doctrine and applying those 3 factors conclude that that the exception does not apply. Finally, I would just say, Your Honor, just real quickly, that both those tests, the attenuation doctrine and the inevitability discovery doctrine, address the same issue. They're trying to answer the same question. And that question is, was the voluntary consent obtained by exploitation of the preceding Fourth Amendment violation, or instead by a means sufficiently distinguishable to be purged of the primary taint? And here, the only reason, the only evidence before the court on this issue is that this homeowner consented because of the illegal search. It was intentional that they informed her of it. They knew it would give them a better opportunity to obtain consent, and they used this flagrant misconduct to get her to consent. All evidence was sought to be seized before the district court. That's what we're asking that district court would do as well.
All right, thank you, Mr. Schultz. We will take the case under advisement. We'll move now to our second case of the day. Appeal number 23-3162. It's Gilbert versus Land's End.
Close the door.
Can I hear that? I was trying to see if we can move it.
All right, we will welcome Mr. Gowdy to the podium.
Good morning, may it please the court. Brian Gowdy on behalf of the 605 former or current Delta employees that claim acute injuries caused by the Land's End uniforms. I will be having 7 minutes with 3 of rebuttal, and then Mr. Nagel, who's on Zoom, will have 5 minutes for the Gilbert appellants. For the Andrews appellants, my clients, there's 3 sub-issues on the summary judgment order. Was there admissible evidence of a manufacturing defect in the uniforms? 2, was there admissible evidence of general causation? That is, was there evidence that the plaintiff's injuries could have been caused by the uniforms? Were the uniforms capable of causing the injuries? And 3, should this court consider specific causation in the first instance or remand to the district court on that issue? Of course, you would need to reverse on the first 2 issues to get to the third issue. I'm going to, with my limited time, I really want to talk about the second issue, which deals mainly with Dr. Freeman and his exclusion. His admission is critical for both the first and second issues. The heart of the win here for Land's End was they were able to exclude Dr. Freeman. And I would just like the court to take a careful look at the briefs. In some ways, they're ships passing in the night, and I would submit that's because Land's End is not confronting the evidence that was in the record and that is stated in the blue brief. As a first example, dealing with the association factor under the Bradford Hill method that Dr. Freeman used. As we say in the blue brief, he did identify an association. We all agree what that means. At page 13 of the district court order, it cites page 566 of the scientific manual, and it states there an association between exposure to an agent and disease exists when they occur together more frequently than one would expect by chance. Well, Dr. Freeman did an analysis that showed that before the employees were wearing the uniforms, and this was based on questionnaires that were sent to over 900 employees, that the average number of symptoms was 0.15. After wearing the uniforms, the average number of symptoms was 2.70. That difference, and he says this right in his report, at Doc 173, pages 20 and 21, that difference of 2.55 is statistically significant. That's mentioned in our blue brief. That is not addressed in the reply brief other than in a footnote. And the argument that they make is, well, that just deals with temporality. And if you read the scientific manual, the Bradford Hill method, the different factors are factors, and they are related. And in his report, yes, it was under a heading dealing with temporality, but Dr. Freeman expressly said that this shows a, quote, strong association, because the number of symptoms, and I'm paraphrasing, but it's on pages 20, 21, the number of symptoms after the exposure was 18 times greater than before the exposure. That's in his report. That's not in the district court's order. That is not addressed in Land's End's brief. They want to act, both they and the district court respectfully, acted like that evidence wasn't there. As another example, Dr. Freeman noted that 48% of the employees' symptoms resolved after they stopped wearing the uniforms. I would like to point out that this is not a case where we're dealing with cancer or some of the more complex issues when we're dealing with causation. These are acute injuries. And in some ways, this is common sense. We're getting close to the holidays. I have one of those itchy sweaters. I know that when I wear it, my skin gets really itchy. And then when I stop wearing, it doesn't. And that's what all of our clients noticed. Not just itchiness. It was far more serious than that. But I'm trying to give you an example that you might be able to relate to at this time of the season, this time of year. This is when I'm wearing the uniform, I have these problems. I stop wearing the uniform, I stop having the problems. In fact, what Dr. Freeman said, again, and this is not addressed in the red brief, not addressed in the district court's order, employees who wore the uniform more than 4 times per week had a mean of 4.38 symptoms and 2.75 systems, compared to those who wore the uniform less than 4 times per week had a mean of 3.72 symptoms and 2.48 systems. Simply stated, the more that you wore the uniform, the sicker you got.
I know you wanted to spend most of your time on causation, but I need to ask about defect.
Yes, ma'am.
As well. Does any amount of crocking constitute a defect under the Uniform Apparel Act?
Does any amount of crocking? Mm-hmm. I would say that you have to show under the law that a defect is unreasonably dangerous. So that's why we've made it clear we're not relying just on Dr. Hauser's testimony about the crocking, but also the dangers that the crocking caused, which is why we point to the other 3 experts' testimony that talks about these materials, how they're toxic, and in particular, Dr. Freeman.
But is there any evidence that goes to that factor of unreasonable dangerousness? There is a lot in the record that says these other elements are present.
Right.
Is there anything that suggests that they rose to the level, kind of that second piece of strict liability, that it rose to the level of being unreasonably dangerous?
Yes, I would say the other 3 experts, including Dr. Freeman. I mean, if wearing a uniform gets you sick,
that's causation. We're wanting to back up and talk about the defect.
I think they're related, Your Honor, because and it's sort of, I think in common parlance we think of defect as, the product was made incorrectly. So, if for example, my coffee machine makes cold coffee, well, that's a defect and I get my money back, but I'm probably not going to get hurt from that. But if my coffee machine makes coffee that's 250 degrees and I get hurt, well, that's unreasonably dangerous. So I would agree with you that just showing crocking alone doesn't get you there.
We're still based on the procedural where this case was, right?
Yes.
We're trying to make this logical, going back to the evidence. What
Right.
was the evidence, using your example of the itchy sweater, not to overshare, okay? Let's say the itchy sweater has 3 holes in your itchy sweater instead of 2. It's defective because there's
Right.
3 and I got 2 arms.
Right.
What evidence makes it, though, unreasonably dangerous?
The questionnaires that our clients answered showing that they were getting injured from these uniforms, and Dr. Freeman's analysis of that as an epidemiologist. You shouldn't get sick from wearing a uniform for work. And yes, that also goes to causation, the same evidence. I mean, it makes sense. If you're going to say a product's dangerous, that's also going to bleed into the causation analysis. So that's the evidence, Your Honor. It's all the questionnaires that our clients answered about their illnesses, and Dr. Freeman's analysis of that, as well as, I'd say, the other 2 experts pointed out, and the lab reports. I shouldn't forget that. The lab reports that Dr. Freeman and the other experts looked at shows that these have toxic materials, and that the mills, overseas mills who produce these, did not properly wash them or scour them, and that caused the crocking. And you see the pictures
But
in our
don't we
brief.
think we're kind of making a leap, because the water resistant, you have these elements in all of the clothing. It's not the fact that the elements are present. It's the question I'm asking is, what evidence is there in the record that those elements rose to the level of being unreasonably dangerous?
What happened to our clients? That's the best evidence. So I've kind of eaten all my rebuttal time. I'm happy to answer any questions.
We'll give you a couple of minutes when you return.
Thank you very
Mr.
much, Your Honor.
Mr. Nagel.
I'm not able to hear him on my end.
Your Honor, am I coming through now?
You
Yes.
are. Thank you.
Thank you so much. Shall I proceed?
Yes, please.
Thank you so much. I am Bruce Nagel, and I represent the class of those affected, stewardess and other Delta employees who had defective uniforms and were denied any right to return or any satisfaction under the 100% guarantee for the particular item. There are 3 undisputed facts that were ignored or overlooked or not addressed by the district court, which I believe defeats summary judgment. And those facts are as follows. Number 1, the warranty issue was included in a confidential agreement only between Land's End and Delta, and was never given to the Delta employees. They did not know what the terms were. Number 2, Land's End prepared a series of talking points which changed the terms of the warranty and only provided for an exchange of the uniforms and did not provide for a refund or a credit as the original guarantee did. And in the talking points, which was the only substantive language that was provided to the employees, there was no requirement that there had to be a form submitted along with the claim. And in the talking points, which was overlooked and not even mentioned in the district court opinion, the talking points themselves said, in quote, "If you are not happy with the garment, there are 2 words to help you rest easy. Guaranteed, period." That's it. There was no reference whatsoever about mechanism of return. There was no mention whatsoever that they are entitled to a credit or refund of the money. And the third key fact that was overlooked by the trial judge is the fact that the warranty provided that in the event of a return of the garment, it had to be done with a form, in quote, "to be mutually agreed upon by the parties." That form is not in the record below, and it's a material factual issue as to whether that form ever existed, because the warranty itself said it had to be mutually agreed upon by the parties, and there is no evidence in the record below that that ever was accomplished. So now, with those three key facts, which inform us in terms of the law, which was not also addressed by the district court, and I believe informs us in terms of the endgame with the jury as to why summary judgment was improvidently granted. With those facts, the jury would have to address Delaware provision section 316(1), which specifically invalidates limitations on warranties and says they are enforceable only if reasonable. So the jury ultimately needs to decide in this case, were the limitations contained in the warranty unreasonable? And the three facts that I just recited to Your Honor, Your Honors, which were in the record and yet not dealt with in the district court opinion, all are factual issues that need to be considered in arriving at the ultimate issue of reasonableness. And in this case, the jury would be charged that A, under Delaware law, warranty provisions are liberally construed in favor of protecting employees. They would have in the record before them the fact that the talking points modified the warranty, number one, and that potentially under estoppel law, Land's End would be stopped from enforcing the limitations of the warranty, A, because they were modified, and B, because they never provided the warranty itself to our employees. And number three, they have to decide whether the three limitations in the warranty would be enforceable at all. Limitation number one, perhaps they'll decide there was no form, so you couldn't use that. Perhaps they'll decide the idea that you had to be a current employee was unreasonable. And number three, they may decide that the idea of returning a defective product is also unreasonable. So ultimately, the three conditions that they argue were not met here, those three conditions are all jury questions, and all are based upon the three factual issues that I referred to. The district court erred by not even making any findings with regard to the three facts I listed, and not even analyzing section 2-316(1) of the Delaware law, which specifically invalidates limitations on warranties. Thank you.
Thank you, Mr. Nagel. We welcome Ms. Williams to the podium.
Good morning. May it please the court. My name is Gwen Williams, and I represent the appellee Land's End. I will, I think, quickly address the points as to the warranty issues that were just being argued. I think we can probably deal with those quickly, and then I'll save more of my time to deal with the personal injury, if that order works for the court. So as to the warranty issue that was just argued, it's undisputed that no plaintiff, not a single one, tried to return a Land's End garment and was refused a refund or exchange. And my opponent focused some of his argument on his argument that, well, the employees weren't given notice of the warranty provision. First of all, any number of Delta employees did decide to return their garments, and the testimony in the record was unanimously that people who did decide to return their garment had no problem accomplishing that. The process was simple and easy. But at the very latest, all of the plaintiffs had notice of the warranty's requirements when plaintiffs' counsel sent Land's End's counsel a demand for refund under the warranty. And he received in response an explanation that said, no, you have to comply with the terms of the warranty, which expressly say that your clients would need to return the garments. He never responded to that letter, and no plaintiff after that point in time tried and was refused the ability to return their garment. And then quickly as to the talking points that were referenced, there's actually no evidence in the record that that information was ever given to the Delta employees. If the court actually looks at that piece of evidence, which you can find at docket 130-4, It's an internal email amongst Delta employees, and it actually says itself, this document is intended for leaders only. Please don't share or forward. So in other words, these were talking points that were going to leaders of teams of flight attendants.
Mr. Nagle is using that as evidence of what the employees were then told, what information they had, since they were intended beneficiaries who may not have seen the contract.
Sure. So my first point is there's actually no evidence in the record that they did receive that information. No plaintiff testified that she had heard those talking points or had any confusion as to that. But even beyond that, even if it's credited that every single employee did get that information, the fundamental point is still in those talking points. You have to return the garment. And that's, I think in today's day and age, I think people are pretty familiar with the concept that if you're unhappy with a consumer product that you bought, you're going to have to return the product. You can't just go say, I'm going to keep the product, but I want you to get my money back. That's just not the way it works. So unless there are other questions on the warranty issue, I will then turn to the personal injury claims.
Real quickly on the crocking subclass.
Sure.
There's no individual plaintiffs left, is there?
As to the property damage claims?
Yes.
That's right, Your Honor. The property damage claims have all been resolved, either because of a settlement or because people who had, the court below gave every plaintiff a period of time to come forward and state if he or she intended to assert a property damage claim, because that wasn't clear from the complaint.
Okay.
So they had time to come forward. If they didn't come forward saying, yes, I want to pursue a property damage claim, those claims were dismissed with prejudice. All the rest of the claims were then settled. So there are no property damage claims left in the case.
Okay.
So as to the personal injury claims, the court focused its questions on existence of defect. So maybe I'll start there and then turn to causation. First of all, I guess I'd like to say the plaintiffs do not dispute that they need expert evidence on defect and causation, both general and specific. Now, as to the defect, they have no expert testimony that could allow a jury to find that any garment without a dye transfer problem was defective. And the undisputed evidence is that many of the nearly 100 garments in the uniform line worn by the plaintiffs had no crocking or dye transfer problems. Mr. Hauser, their textiles expert, he was quite clear that his opinion related to the situation where the purple dye would transfer, right? It would rub off on your skin or perhaps your undergarments, and that when that happened, when the dye transferred, the dye could carry with it, and did in certain occasions, certain chemicals. And he identified 4 specific chemicals, and only 4. And that is the only, and he testified that makes the product defective. There was lab testing that showed that certain garments had other levels of chemicals, some of which might have exceeded industry standards, some of which did not. But there was no testimony from Mr. Hauser or from Dr. Freeman, who wouldn't be qualified as an expert on defect anyway. There was no evidence that the presence of any of those other chemicals in any other garments besides the purple dye transfer issue, that was a product defect. And what the plaintiffs claim essentially is it's just a post hoc theory. I wore the garment, I experienced some symptoms, it must have been something in the garment. And although my opponent argues that this is sort of common sense, we've all had the experience of wearing a sweater that's itchy, he actually really minimizes the claims of many of his clients, because they're not just about experiencing some itchiness or some skin rash. The range of ailments that were put forth by the 600 different plaintiffs, collectively between them, it was nearly 40 different ailments. And it's not just skin rashes. It was asthma, it was upper respiratory infections, it was hair loss, it was shortness of breath and heart palpitations. those are not the kind of things that a jury could just draw on its own common sense and say, well, yeah, it must have been because they wore these garments. As to then some of the points that my opponent made regarding the exclusion of Dr. Freeman's testimony, he focused for one point on the association issue under the Bradford-Hill test. And I just wanted to clarify what the argument is as to Dr. Freeman's failure to properly satisfy.
Can I just back you up for a
Of
minute
course.
on the general causation question?
Yes.
Is there any evidence to suggest out of the 4 chemicals that were identified by the expert that any of those 4, just those 4, rose to the level of being unreasonably dangerous?
Yeah, well, no, Your Honor, and they don't have anything to link those chemicals to the ailments. In other words, it's not enough to say, well, there were a whole bunch of chemicals, and altogether these chemicals could cause this large number of possible symptoms. You'd have to actually say, okay, what we have here is this garment that this person wore when the dye transferred, it transferred these 4 chemicals.
Right.
And those 4 chemicals were at a level that was dangerous, and of course those 4 chemicals actually could cause, for instance, if the person's claiming
And
hair
that's
loss.
that second piece that I'm asking.
Okay.
I'm trying to figure out, is that link in the evidence?
And so what was very interesting was my opponent argued multiple times to Your Honor about the 3 experts. Well, I'd like to point out that 2 of the experts, Dr. Scheinman and Dr. Apple, they didn't appeal the court's exclusion of those experts. So Dr. Apple was the toxicologist who, at least to some extent, purported to get to that aspect that Your Honor is talking about, right? The toxicology of it. And I think if the district court's decision discussed in length, and I think quite convincingly, why Dr. Apple's testimony as a toxicologist, it's the right kind of expert, but his analysis was completely lacking. And again, the plaintiffs did not appeal the exclusion of the toxicologist or the dermatologist. The only piece of the expert opinion that they appealed was the court's exclusion of Dr. Freeman's general causation testimony. And while I'm on that topic, I would just like to note, as a bit of an aside, that Dr. Freeman purported to offer expert testimony as to both general and specific causation. The court below excluded both general and excluded everything, so general and specific causation evidence from Dr. Freeman. And on appeal, the plaintiffs only argue that the exclusion of the general causation evidence was manifestly in error, not the specific causation.
But tell me this, should the district court have considered Dr. Freeman's opinions about specific causation?
No, Your Honor. It was also wholly lacking for a whole host of reasons. The way in which he considered specific causation was through application of something called the Naranjo algorithm, which basically consists of sort of looking at at the records that he had for each plaintiff, which were just these questionnaires, and sort of assigning a number of points based on certain criteria. And then if you're over a certain number of points, you can say, well, then that gets me to causation. As he admitted in his deposition, that algorithm has never been used outside of the context of adverse drug reactions. It's a totally different kind of analysis. He could provide no support for the notion that you could use it to determine specific causation in the context of a toxic tort case like this. Further, although her testimony was excluded, Dr. Scheinman, the dermatologist, who was certainly a very well-qualified dermatologist, spoke at length about what it is, at least as to things that fell within her area, dermatological issues, what it is that you would actually have to do to determine specific causation. She was quite clear that she would never try to determine specific causation for a dermatological condition without having much more information than Dr. Freeman had. She talked about how she would want to take a medical history. She would want to talk to the plaintiff herself. I think she said that she'd never tried to do it from just looking at medical records taken by a different doctor. And Dr. Freeman didn't even look at the medical records. They were available. Many medical records had already been collected by that point in time. He did not go to the medical records, he just used the questionnaire information. So there's a host of reasons why the court was correct in excluding the specific causation opinion as well. And the specific causation opinions were, there was some of it in each of Dr. Scheinman, Dr. Apple, and then that portion of Dr. Freeman's testimony. So by excluding those three experts, specific causation evidence was excluded. All of the expert testimony was excluded, and that would leave only the relatively small number of plaintiffs who had also come forward with treating physician disclosures.
I know you had mentioned that in your briefing that any of 50 states, as far as defect, are you conceding that Wisconsin law would apply here?
For purposes of the argument, I think it's a perfectly reasonable conclusion. I mean, if we were to go to trial as to any particular plaintiff, if he or she did not live in Wisconsin, I think it would be a valid choice of law question at that point in time about which law should govern this particular plaintiff's claim. But the district court concluded that it didn't need to get into really the choice of law question because as to the existence of defect and causation, the law was similar enough in every jurisdiction that it could just apply Wisconsin law, and we did not take issue with that. I would note on that just that the plaintiffs in their briefing tried to make much of the fact that Wisconsin uses a consumer contemplation test for defect, and I would just want to point out that that test, perhaps somewhat misleadingly named, doesn't mean that it is enough to establish defect by a plaintiff simply saying, I used this product and it was more dangerous than I thought, so therefore it's defective. And in fact, the case that's discussed in the briefing about this, the case against Smith & Nephew, the latex glove case, in that case there was substantial expert evidence about the product, about the characteristics of latex, about whether latex could give rise to allergies. It was not simply that the jury was being asked to just sort of decide whether this particular nurse who had developed an allergy, whether she herself subjectively thought that the product was more dangerous than she had contemplated. That's not what that test means.
All right.
Thank you, Your Honor.
Mr. Gowdy, we'll give you 2 minutes.
Thank you. May it please the court. A lot of the statements you heard were many, but not all, some of which exceeded industry standards. Besides the purple transfer, the arguments you heard were as if this was a class action. This is about 605 individual plaintiffs. And so they want to say, well, maybe most of the people didn't have a problem. When we get down to the specific causation analysis and the trial, we'll see which of these 605 plaintiffs have it. Where the summary judgment was simply on defect and general causation. The judge did not rule on specific causation. I wanted to also point out that they have again misstated that Dr. Freeman relied on the algorithm, the alternative method for only specific causation. He was very clear in his report that he was doing it for both general and specific causation, and the district court failed to know that. It skipped over the whole general causation opinion in his order, and they've done it again here. They don't want to look at that part. And that was alternative to the Bradford-Hill method. And it's not even addressed in the order. The order just addresses his specific causation opinion under the algorithm. And their brief does the same thing, and their argument that they just had. Just skip over that. It's in there, and where we've cited it. The other, as far as what we're not appealing, It's true we're not appealing the exclusion of the causation opinions of two of the experts, but the district judge never excluded their opinions or Dr. Freeman's opinions about the toxicity of what's in these uniforms. That wasn't excluded. What was excluded were the causation opinions. And there's abundant, I also wanted to get back to your the four elements. Dr. Hauser, I just reread it as I was sitting over there. He notes that in one of the tests, I'm on my red light. So if you could reread it closely, he notes that one of the tests has those four, but we don't know, we just know there was crocking, and there was all these elements, and you can look in Dr. Freeman's report. He lists the elements. So thank you for the time today.
Thank you. We will take the appeal under advisement. We turn now to our third case of the morning, appeal number 24-1440, Metroplex Communications versus Meta Platforms. And we welcome to the bench retired Judge Feinerman. Good morning.
Good morning. May it please the court, counsel, I'm Gary Feinerman on behalf of the defendant, appellant, Meta Platforms. Metroplex's suit alleges that Meta made false statements about the estimated audience for Facebook ads. So the suit is about buying ads on Facebook. The arbitration provision in Meta's commercial terms to which Metroplex agreed broadly covers claims that pertain to the buying of ads on Facebook. The provision applies to any claim that relates to any access or use of the Meta products for business or commercial purposes. And the terms define business and commercial purposes to include using ads. So Metroplex's claims relate to any access or use of Meta's products, here Facebook ads, because they rest on the premise that customers who are buying ads bought ads on Facebook rather than on any of Metroplex's properties. So based on the plainest reading of the arbitration provision, those claims fall within the scope of the provision. The district court disagreed, and it disagreed by reading an implied by you into the definition of commercial claims. Instead of reading the arbitration provision to apply to claims that relate to any use of Facebook ads, the district court read the provision to apply only to your use, meaning Metroplex's use of Facebook ads. And that ignores the provision's text, which says any, not yours. And the text is not limited to Metroplex's use of the Facebook ads. And it's important, I think, to distinguish Section 5A from Section 5B. And they're both in the disputes provision of the commercial terms. It's on page 265 of the joint appendix. And what it shows is that when the parties intended a provision to be limited to the user's use of Facebook ads, meaning here Metroplex's use of Facebook ads, it knew how to do so. Section 5A has to do with third-party claims. And what it does is it provides that the user has to indemnify Meta for third-party claims brought against Meta that relate to your use of the Meta products. Not any use, meaning use by anybody, but your use, meaning use by the party to the commercial terms, your Metroplex. Section 5B, by contrast, along with sections 5C and 5D, pertain to first-party claims involving the user and Meta. And unlike Section 5A, it covers claims related to any use of those products, meaning use by anybody. And so under standard interpretive principles, even without the overlay of the FAA's presumption in favor of arbitration, but particularly given the overlay of the FAA's presumption, the Section 5B refers to any use and not just Metroplex's use.
Before you continue with your textual arguments, can we back up for a minute? Is there
course.
anywhere in the record where Meta admits to purchasing ads through, where Metroplex admits to purchasing ads through Meta for its clients? Because I'm seeing different spots, but they don't seem to be concessions or actual admissions that Metroplex purchases these ads.
I mean, Metroplex is kind of squirrely about whether or not it purchased ads. I think if you look at the Pricer Declaration, which is at Joint Appendix 109 to 122, and in particular, I'm sorry.
You said 109?
I'm sorry, that's not the, that's not, the Pricer Declaration is, I'm sorry, Joint Appendix 138 through 142. It lays out why the evidence of record shows that Metroplex had Facebook pages on Facebook. It had commercial pages, one for its radio station and the other for its news property. And it establishes that ads were purchased in order to advertise those Facebook pages, those radio stations, and those ad properties. And then the question that Metroplex never answers is, who would have bought those ads? Who would have agreed to the commercial terms on behalf of Metroplex if it weren't Metroplex? And what the Pricer Declaration does is it connects the dots between the purchase of those ads directly to whoever it was who was administering those pages on behalf of Metroplex.
Okay. But you would agree we don't see this in the complaint. And at most, when they respond at the hearing, it was the April 2023 hearing, they admit they purchase ads on behalf of their clients.
Right.
But not that specifically that they do it through Meta.
They do purchase ads on behalf of their clients, and the evidence in the Pricer Declaration shows that they purchased ads not only on behalf of themselves, but also on behalf of their clients. And I think if you look
Mr. Feinerman, can you
yes.
connect that, though? Because the amended complaint has, I think, no allegations about Metroplex as an account user or a consumer, correct? It's always as a competitor. And so Metroplex could have, the fact that they purchased ads, if they did,
Right.
really has nothing to do with this lawsuit, does it?
It does, and it does for two reasons. One is it's covered by the arbitration provision, and I think let's take a step back and think about, one is covered by the arbitration provision, even under our understanding of the arbitration provision, which it applies to any use of the Facebook ads, regardless of whether it's by Metroplex or third parties. But even under a narrow understanding, even under Metroplex's understanding of the provision, the claims also relate very directly to Metroplex's own use of the Facebook ads. And I think it would be helpful to kind of take a step back and think about the commercial relationship here. Like, why would, I sense that Metroplex is asking, and perhaps that prompts your question, why would Metroplex agree to an arbitration provision that covered anybody's claims relating to anybody's use of Facebook ads rather than just its own? It's a commercial relationship. Placing ads on Facebook is very, very valuable to businesses. That's why Metroplex did it. And in exchange for that access to Facebook's platform, the purchaser of the ads here, Metroplex, has to pay money. It also has to agree to a number of non-monetary provisions. Limitation of liability, which is on Section 4, covering indemnifying for third-party claims, Section 5A, and arbitration, which is Section 5B. And Section 5B, read textually and correctly, particularly under the FAA's presumption, covers any access or use to the Facebook platform, and not just Metroplexes. But let's say you disagree with me on that, and I hope you don't. Even accepting the district court's atextual limitation on the provision's text, Metroplex's claims necessarily relate to its own use and purchase of Facebook ads. If this case remains in court, Metroplex is going to be the star of the show, whether it's an individual case where there's only one plaintiff, or whether it's a class action where Metroplex is the named plaintiff. And Metroplex's purchase of its own ads on Facebook and the placement of ads on Facebook, not only for itself, but as it admitted in front of Judge Dugan on behalf of its clients, are directly pertinent to its claims, both liability and damages. I'll quickly go through them. In terms of liability, one element of Metroplex's claims is that Meta's allegedly false statements were material to ad buyers. So what Metroplex is alleging is that if the ad buyers had only known that Meta was exaggerating the reach of Facebook ads, it wasn't, but let's just assume that it was, the ad buyers would have impacted the ad buyers' decisions whether or not to buy ads on Facebook, and that's at paragraphs 367, 377 to 388 of the complaint. That plainly implicates Metroplex's own ad purchasing behavior. In particular, it's continuing to purchase ads on Facebook after 2018, when the DZ Reserve case was filed in federal court in California.
But can we talk a little bit? I noticed that you acknowledged page 22 of your reply brief.
I'm sorry?
Yes, I noticed on page 22 of your reply brief, I think it's footnote 2, there's a reference to the Viking River Cruises case.
Right. Yes.
And so you know where I'm headed with this question.
I do.
What is the causal connection between the commercial terms of this contract, particularly on page 265, and the Latham Act suit that Metroplex is bringing here? I'm trying to connect just so that we're in keeping with the Viking River Cruises case.
Right. I'm not sure. I mean, the Viking River Cruise reference to Section 2 was in a footnote. And I'm not sure that the Supreme Court meant anything other than whatever causal relationship is required by Section 2, it was satisfied in the Viking Cruise case. But in terms of, is your question, why does this provision read in our way fall within the scope of Section 2?
Yes.
Right. So Section 2 states that an arbitration, a written provision in any contract evidencing a transaction involving commerce to settle by arbitration a controversy thereafter arising out of such contract or transaction shall be valid, irrevocable, and enforceable. And so what Section 2 lays out are about 4 or 5 tickets that have to be punched before an arbitration provision can be covered by Section 2. It has to be written. It has to be in a contract. The contract has to evidence commerce, and what back in 1925, what they meant by that was it has to be in interstate commerce. And it has to settle by arbitration a controversy arising out of such contract or transaction. And if all those tickets are punched,
and so
then
let's
the
just
provision,
focus on number 4. How
Right.
is it this particular claim arising out of? I think that's where the disconnect is.
Right. I'm gonna, in terms of the premise of your question, I'm gonna say that that question speaks to the breadth of Section 2. Section 2 does not apply, so I guess I'm questioning the premise of your question, if you'll allow me. Section 2 doesn't operate on claims. It doesn't say claims are subject to arbitration if this, that, and the other thing. It says a written provision is subject, is enforceable if it does this, that, or the other thing. So as long as the written provision has a hook that does apply
And that's where
to claims.
that's why I'm pushing back a little bit
Right.
to say, what is the hook when I'm looking at particularly disputes, looking at this contract here.
Right.
And it limits it to, if we're using this word any,
Right.
right? When we're using it in section 5B, for example, are we using the natural reading of that word any for 5A and 5C that come right before it and right after it?
Right. Yeah, absolutely. It's because any means any and your means your. And in terms of Section 2, though, as long as the provision encompasses claims that arise out of the contract, it's in FAA land. And once a provision is in FAA land, it's enforceable, certainly to the extent that it covers claims arising out of the contract, but also if it pertains to claims that arise out of different sources of law, different contracts like in Gore or Carr's Notion, or different statutes like Epic Systems, which is the FSLA, and American Express, where those claims arise out of the Sherman Act. If the very narrow reading of arising under were correct, and no court has read Section 2 that narrowly, not even Calderon in the 11th Circuit, then all of those cases, it would wipe away a broad swath of cases that applied Section 2 of the FAA to claims that did not arise directly out of the contract. So I think and I see it that I'm out of time.
You can finish your thought.
Sure. So the
Briefly.
best way to read Section 2 is it creates an entry pass into Section 2. As long as the provision does cover, part of the provision covers claims that arise out of the contract, then it can carry everything else, all other claims, with it that are covered by the text of the provision, and that's illustrated by the cases that I just mentioned.
Thank you. We will welcome Mr. Gelfand.
Good morning, and may it please the court. The district court in this case correctly held that the arbitration agreement at issue does not apply to this Lanham Act case, this unfair competition case, brought by a company wearing the hat of a competitor of Meta, a competitor of Facebook, as opposed to the hat of a customer, a consumer of Meta. But even if this court were to read this arbitration agreement in a way that we believe would be incorrect, but
Mr.
consistent...
Gelfand, I'm sorry, are you conceding that Illinois contract law applies here?
Yes, Your Honor, we believe Illinois contract law applies here, and we believe Illinois contract law supports our interpretation of this contract. To be clear, and this was true at the lower court below, there was no real dispute between whether Illinois or California contract law applies because it doesn't really affect the ultimate analysis in this case.
For purposes of our analysis, Illinois law?
Yes, Your Honor, to be clear, for purposes of this court's analysis, Illinois law applies to the contractual interpretation, but of course the FAA choice of law provision applies for purposes of how this court interprets and enforces the contract. And so
I understand how it works. I just need to know which state law you're going with.
Illinois, Your Honor.
Thank you.
And so with respect to the FAA, the underlying question is, does this dispute, does this lawsuit that we brought in this case on behalf of Metroplex arise out of the contractual relationship? To that point, the U.S. Supreme Court in Viking River Cruises did not inadvertently put a footnote in that has no legal significance, emphasizing that there has to be a causal connection. But even if this court were to look no further than its own precedent in the Gore case, then the question becomes, does this dispute have its origin or genesis in the provision at issue? These unfair competition claims that are the heart of this case, the subject of the first amended complaint, do not arise out of Metroplex's use or access of Facebook. They arise irrespective of any customer relationship or agreement between Metroplex and Meta. And the reason why is because the theory that we're dealing with here, the issues that we're litigating in this case, focus entirely on the false statements that Meta made in commerce as it relates to the number of people using Facebook, the audience size, everything that's at the heart of what's alleged in the first amended complaint. To that end, to be clear, Meta's argument is not, as Judge Feinerman suggests, the plainest reading. As the district court correctly heard, the plainest reading of the arbitration agreement at issue is the reading that is consistent with Section 2 of the FAA, which the parties expressly in this provision agreed governs not only the enforcement but the interpretation of this contract. And that means that any refers to any access or use, any method of using, any number of times it's used, but not to anybody's use. The irony of this is that it's Meta that's actually asking the court and asked the district court below to essentially replace the word any with its own word, anybody's. And there's no basis to do so. Now, Judge Feinerman keeps referring to this so-called presumption of arbitration. I wanted to hit that right at the outset, because as the US Supreme Court and this court has repeatedly held in the context of this very issue, as it applies to what we're litigating here before this court, the policy is to make arbitration agreements as enforceable as other contracts, but not more so. That's word for word what the US Supreme Court said in the Morgan case. This court, in the Johnson case just 2 years ago, in 2022, referenced a defense argument similar to the argument that's being brought before this court this morning, that the FAA requires that arbitration agreements be generously construed and that all doubts be resolved in favor of arbitration. And what this court says is, that is not, however, what the statute says. In other words, the FAA requires arbitration agreements to be treated just like other contracts. And this court referenced 9 U.S.C. Section 2, in other words, Section 2 of the FAA, that's at the heart of our argument. That's consistent with what this court held in 2003 in the Stone case, saying nothing in the FAA overrides normal rules of contractual interpretation. So ultimately, the bottom line takeaway here is that this is a reaction to perhaps a long time ago a view that arbitration agreements should somehow be disfavored. And what the body of law holds, what the clear authority both at the Supreme Court level and at this court level stands for, is a very simple premise, which is arbitration agreements should not be read in a way that are different from any other contracts. They shouldn't be interpreted more favorably to reach a particular result or less favorably to reach a particular result.
One of the things that we're confronting is when a party, or here your opposing party, offers a contrary interpretation of a clause. When does that rise to, a plausible interpretation that creates ambiguity? That is, as you would agree, if there's ambiguity under our law, it pushes us to arbitration. So where on that sliding scale should we find ourselves or root ourselves between someone's plausible reading and where we go from there?
It's a good question, Your Honor, but I think in this case, the premise I would push back on is that I don't believe there's actually any ambiguity as the district court correctly held in the contract in this case. And one of the reasons why is not only the contract provision itself, which clearly refers to any access or use by the parties that entered into the contract, in this case Metroplex and Meta, but also that the contract itself incorporates that the FAA is the guiding post here that applies for both interpretation and enforcement. And the reason there's no ambiguity, and the reason that's relevant here, is that our interpretation of the contract, for lack of a better phrase, is the only way to reconcile the contract language itself and Section 2 of the FAA, that they both deal with limiting arbitration to disputes that arise out of, that's the statutory language Congress used, and the language in Facebook's contract here is that arise out of or relate to the use of Meta's platform, meaning Facebook for these purposes, for purposes of business or commercial use. And so this is not a scenario where there's ambiguity. I would also urge the court that when, to the extent that the court believes, notwithstanding our position, that there is some ambiguity, then normal rules of contract interpretation should apply to try to figure out what was the party's ultimate intention here with respect to this contract. And so the solution is not what Meta essentially argues in its own way, which is let's just jump to there's some abstract ambiguity in some esoteric manner, let's now immediately say arbitration. Then we resort to all these other tools, and that's all they are, to interpret what was ultimately the intent between the parties. And that, Your Honor, is where the reconciliation between the agreement within the contract that the FAA applies to the interpretation and to the enforcement of the contract is critical. That's section 5.C.2 of the contract itself. And so to that end, when we have a case as we have here, where a competitor of Facebook is raising claims that exist irrespective of whether that competitor happens to, at some point in the past, had a Facebook page, that falls outside the scope not only of the plain language of the arbitration agreement that we're dealing with here, but it also falls outside the scope of the FAA itself. And that's where the district court should be affirmed on its face. But what's interesting is even if this court were to say, no, we read the contract differently from the district court, then it falls outside the scope of the FAA, and then it begs the question of whether this court has jurisdiction on appeal if it's outside the scope of the FAA, consistent with precedent like International Board of Teamsters. In all candor, I don't think the court needs to get that far to some of these questions about jurisdiction, because consistent with the district court's opinion, the contract itself just doesn't apply to these claims.
Can you characterize or clarify the different types of clients that you are alleging to have lost because of Meta's statements? The parties are somewhat kind of talking past each other about the contours of your theory.
Yes, Your Honor. The underlying premise of this litigation, and of course this will be developed appropriately through discovery, is that there is an entire marketplace of ad buyers, people that purchase digital advertisements on platforms like Metroplex through its own platforms, like Facebook, and of course like a number of other, perhaps including some of the most, largest companies that exist. To that end, when Facebook does what it has done in this case, which is makes false statements about, for example, the number of people using Facebook, the number of monthly active users, the number of quantification of certain accounts, description of potential reach, of metrics representing people, then that has an effect on any consumer that is purchasing ads. And in this particular instance, Metroplex is wearing the hat not as a consumer purchasing ads, and that's what's so relevant to the issue before this court, but is wearing the hat exclusively as a competitor that, like Facebook, I'm using Facebook interchangeable with Meta, but that, like Facebook, is selling advertisements and competing, so to speak, for the same consumers. And that's what really strikes at the heart of this case, because if this case were a case involving Metroplex's claim, by way of just a random example, if Metroplex hypothetically went on to Facebook as a consumer, purchased ads and claims, well, you didn't run my ads, then Meta would have an argument that arises out of this contractual relationship. But in this particular Lanham Act case, it's not only one step too far, it's about 100 steps too far. And that's exactly why the district court correctly ruled as it did. Now, furthermore, we're not trying to pave new ground. There's been some suggestion in the reply brief, and Judge Feinerman alluded to it broadly today, that we're trying to basically create some novel legal theory. It's going to create some circuit splits, and that's not so. What we're arguing is consistent not only with the plain language of the statutory language at issue in 9 U.S.C. 2 that it arises out of, but it's also consistent with this court's precedent in case after case after case where the FAA was interpreted to involve disputes over contracts. I'm sure I'm pronouncing this wrong, but IBU local, it's a dispute over a contract's grievance procedure. Gore, the claims have to be the origin or the genesis in the underlying contract. Falkenberg involved claims with a franchise agreement. United Steel was a breach of agreement. Exelon, a collective bargaining agreement set of violations. These are all contractually based disputes, as opposed to the Lanham Act and parallel Illinois State Unfair Competition Act allegations that are at issue in this case. To that end, there is a threshold question that this court needs to address for Meta that was asked to Meta as well, and that's what the record reflects with respect to Metroplex purchasing ads in the first place. And to be crystal clear, Metroplex is not being squirrely. That was the word that was used by Judge Feinerman. This is Meta's burden to establish at the lower court level, and Meta failed to establish at the lower court level that there even is an enforceable arbitration agreement in the first place, putting aside everything else. This court, as recently as July of this year in the Walrich case, Walrich, made it clear that the party seeking to enforce an arbitration agreement is the party that bears the burden. That's not new law. That's just reflecting what we could find as the most recent iteration of that legal standard. And so what this court is faced with is a contract itself where the plain meaning of the language, especially when reconciled with Section 2 of the FAA, as incorporated within the statute itself, within the contract itself, Section 5.C.2, that the FAA governs interpretation and enforcement of the contract. The way to reconcile that is the way that we're asking this court to read the plain language and to get to the ultimate meaning of the parties. That's consistent with the Supreme Court's footnote, but important footnote in Viking River Cruises. It's consistent with this court's binding precedent in Gore, and it's consistent with everything else that the district court said below. And so for all of these reasons, if there are no more questions, we would ask the court to affirm the district court's decision.
Okay, thank you, Mr. Gelfand.
Thank you.
Judge Feinerman will give you 2 minutes.
As to whether some rogue third party or elf or gnome bought Metroplex ads for Metroplex that were advertising Metroplex's property, I didn't hear counsel deny that Metroplex had bought ads for itself. Of course he couldn't.
Okay,
because
I'm
they
getting accustomed to the hypotheticals this morning. Everybody has one. So let's use a different one. We had the sweater before, now we got the elf and the so if we have the hypothetical delivery driver, okay?
Right.
Let's say using Meta's new smart glasses, crashes into Metroplex's building.
Right.
The advertiser wants to sue Meta. Must it arbitrate?
No.
Why not?
It comes down to the word related to. And, there's the parable of the butterfly in Brazil flapping its wings, causing a tornado in Texas. At some point, the causal relationship gets too attenuated, and something is no longer related to. And that's not the case here. The arbitration provision covers any access or use of Facebook ads. These claims pertain to the sale and purchase of Facebook ads. So there's a much, much tighter nexus here than there is in the glasses provision. But in terms of what the record shows, I just want to make perfectly clear, because the panel asked questions of both of us as to whether Metroplex bought ads. The answer is yes. I'd point the panel to paragraphs 25 through 30, which is Joint Appendix 139 to 142, very clearly shows that. In terms of whether there's still a presumption, United Natural Foods, after Morgan, after Johnson, held that there was. That's still good law. Morgan and Johnson did not eliminate that presumption without saying so. Thank you.
Thank you. We thank both parties, and we will take the case under advisement. All right, we'll turn to our fourth case of the morning, which is Anderson versus United Airlines. Appeal number 24-1626. And we welcome to the podium Mr. Green.
May it please the court. Good morning, Your Honors. My name is Andrew Green on behalf of Thomas Anderson and 27 other former United Airlines employees that were affected by their vaccine mandate. Here today, we're seeking to overturn the district court's order denying motion for leave to amend and dismissing the plaintiff's claims with prejudice. Today, with such limited time, we did have 12 claims for relief. I would like to discuss 5 main issues that United defends themselves on. First, although the FDCA does not explicitly allow for private right of action, one may be implied. Second, to get this implicit private right of action, when there's a due process violation, as there was here, the infringement on the fundamental right to refuse unwanted medical treatment, you can have a cause of action. Third, United is not immune from constitutional claims just because they're not a state actor in the traditional sense. They were so entwined with the federal government, thus subjecting them to liability. Fourth, the failure to exhaust administrative remedies, again in the traditional sense, does not bar all of plaintiffs' claims. Fifth and finally, the district court had adopted the wrong standard for plaintiffs' Title VII failure to accommodate claims. Under Title VII, disparate treatment is not treated the same, which this court has held, as disparate impact claims. As United repeatedly cites that the FDCA does not explicitly create a private right of action, the private right of action may be implicit once fundamental rights, such as the fundamental right to refuse unwanted medical treatment, is infringed upon. So there are 2 avenues, which we argued in our brief, which we show a due process violation. And as the Supreme Court already held in Bivens, which we state on page 17 of our reply brief, a private right of action may be implied when there's a due process violation. First, the fundamental right to refuse unwanted medical treatment, as well as the infringement on, an equal protection clause violation. We discussed this on page 15 and 18, Cruzon, of our initial brief, as well as page 17 of our reply brief. Cruzon held that the principle of a competent person has a constitutionally protected liberty interest in refusing unwanted medical treatment, and that may be inferred from the Supreme Court's prior decisions. Cruzon also cites to Jacobson, which is repeated throughout every COVID-19 case practically, and a series of later cases which support the recognition of a general liberty interest in refusing unwanted medical treatment. United also cites to Washington versus Glucksberg, decided 7 years after Cruzon, which the Supreme Court held in 1997, which explained that the right of a competent individual in refusing unwanted medical treatment was entirely consistent with the nation's history and constitutional traditions in light of the common law rule that at common law, if you force medication on someone, you were subject to a battery claim. And there was a long legal tradition protecting the decision of the refusal of unwanted medical treatment. The case law clarifies that compulsory treatment for the health benefit of the person treated implicates the fundamental right to refuse medical treatment. At the time of the issuance of United's policies with the COVID vaccines, there was a lot of unknown in the world. At first, we didn't know about boosters. We didn't know about the efficiency of the vaccines themselves. We didn't know how the vaccine would affect transmission to other individuals. We didn't even know how beneficial it was to the individual getting the vaccine. Moving on to the second issue was the equal protection violation. When there's an equal protection violation, you may implicate a private right of action, which we discussed on page 18 of our reply brief.
And so that one would be waived, right? If you raise it for the first time in reply.
Correct, Your Honor.
So let's move to the next one.
Yes, Your Honor. So the second defense that United cites to, that they claim immunity, is because they're not a state act in the traditional sense. Now, this court has held in Hanania versus Lauren Maltese, pardon me if I mispronounced it, that a private individual acts under color of law if there was a concerted effort between the individual and the state actor. Now, discovery is needed to further clarify and clear up the relationship between United and the federal government, but what is shown is that both shared in the unconstitutional goal of global vaccination. In our second amended complaint at paragraph 184, we even stated that there was a clear relationship. In April of 2020, the federal government, through the United States Treasury Department, gave United Airlines $5 billion in exchange for approximately 4.6 million shares of United Airlines stock. Given such a substantial influence over United, they could clearly influence their policies and mandates. United also states in their brief that private actors are not beyond the reach of 42 U.S.C. 1983, acting under color of law. In our second amended complaint, paragraph 314, we specifically allege that United conspired with government officials to achieve the Biden administration's goal of universal vaccination. Again, the government paid for and funded all the COVID-19 vaccines, and then United mandated that every single one of their employees get the vaccine. They shared this common goal of universal vaccination. Essentially what they're saying is get the jab or lose your job. Now, the defendant's cite to Jacobson, like I previously mentioned, is cited in basically every COVID-19 vaccine case. There needs to be some transparency about how the two cases are different. Jacobson is a 100-year-old case and involved a smallpox vaccine that was not issued through the EUA. The EUA allows the issuance of a vaccine before every necessary protocol and step is taken to assure its safety and efficiency. So in Jacobson, you had the smallpox vaccine issued not pursuant to the EUA, but through regular protocols. The penalty that the Commonwealth of Massachusetts assigned to individuals that did not receive the smallpox vaccine was a forfeiture of $5. It's not lose your job, not lose your livelihood, which my clients suffered here. The COVID vaccine here was issued pursuant to the EUA. It didn't go through every single necessary protocol.
Maybe we should move forward if we're not going to, because there was a finding that this argument had been forfeited. And in Benson, this court has already held that there is not a private right of action under the FDCPA. And so if in the limited time that we have left, should we talk through the Title VII claims?
Yes, Your Honor, we can do that. So as I mentioned previously, I think the position we stand on is that district court applied the wrong standard for the Title VII claims. They cite to a case that actually applies a disparate impact rather than disparate treatment claim. This court has already stated that they're not.
Can we back up just for a moment to answer the question as to whether or not these claims are barred? Because is there a right to sue here in the, go ahead.
Yes, so we do believe there is a right to sue here. And are you referring to the previous, my previous argument about private versus state actors?
With the Title VII claims, and I know that you're aware of this, before we can proceed on those, there has to be a right of sue letter issued by the EEOC.
Right.
And so looking at the claims, there was an argument raised that we're barred from hearing because there was a failure to exhaust. And so I'm really asking if you could address that argument.
Yes, Your Honor. So page 18 of our appellant brief begins our discussion of the exhaustion of administrative remedies. And this court has waived the requirement for the traditional exhaustion of administrative remedies, where the exhaustion causes prejudice due to unreasonable delay or an indefinite amount of time. Second, the appealing through the administrative process would be futile. Or third, where substantial constitutional questions are raised. The EEOC's website itself, which we cited in our complaint, stated that the turnaround time for a decision could take many months. Here, the pilots and employees of United did not have the amount of time of many months. United implemented the policy, and then 1 month later, employees were subject to termination. Third, and as I previously discussed, substantial constitutional questions are raised in this case. The Supreme Court has repeatedly expanded and narrowed what is included in the fundamental right of the refusal to unwanted medical treatment, which is again cited in Cruzon versus Director of Missouri Department of Health, which was decided in 1990, which we cite to page 20 in our appellant brief. The pandemic was an unprecedented time in this country. The issuance of vaccines and policies that were ever changing, it seemed like, without a doubt raised constitutional questions that were the subject of this matter. And with that, I would like to reserve the rest of my time for rebuttal, please.
You may. Thank you.
Thank you, Your Honors.
And we welcome Mr. Majeri to the podium. You can correct my pronunciation when you arrive.
Good morning, Your Honors, and may it please the Court. Alexander Malgeri with Jones Day on behalf of the United Airlines defendants. Your Honors, the judgment here should be affirmed for 3 simple reasons. First, despite 3 opportunities below, including an opportunity to amend their complaint after United's motion to dismiss, including after a thorough decision by Judge Kennelly outlining the deficiencies in their claims, the plaintiffs have not stated any claims against United Airlines. At bottom, as you heard this morning, discussions about the Biden administration and the federal government, the plaintiff's grievance is really against the nation's response to COVID, the COVID vaccines, as opposed to the airline. And that's why their claims do not fit the legal elements here.
Which of plaintiff's claims, if any, do you think have been properly preserved for us to address?
Respectfully, none, Your Honor. Each claim has a forfeiture to a key element, and I'm happy to march through those.
Why don't you address then the whistleblower claim?
Sure. So, Your Honor, the Illinois whistleblower claim has a few problems, including forfeiture. So, first, as we argued below, the Whistleblower Act section that the plaintiffs have invoked, 740, Section 20, requires that the plaintiff be asked to participate in illegality. There's nothing illegal about obtaining the COVID vaccine. So what plaintiffs are trying to do is bootstrap alleged illegality as to United through the whistleblower statute. We cited to the text of the statute, we cited to Illinois Supreme Court precedent on that, and they did not respond below. The district judge held that they forfeited that argument. The judge also held that they forfeited any argument based on Title VII, and on appeal, with respect, it's very difficult to understand which illegality the plaintiffs are pressing. As best as I can tell, they're trying to press on some sort of a common law retaliation claim, and respectfully, that's waived. I can discuss sort of why it fails on the merits if Your Honor would like, but that claim has no merit. Unless there are other questions about the whistleblower claim, I'd like to discuss the claims that we did here this morning, as well as just make 2 threshold points. So as I was going to say, and as Judge Pryor raised, there are many issues of forfeiture here, and it's hard to imagine a more compelling case when the court should simply affirm without reaching the merits. We've outlined all of those reasons, but those problems extend to the fact that plaintiffs' briefs on appeal do not cite the record. They don't cite the complaint. So it's impossible for the court to judge the sufficiency of the allegations. And one third point, we've talked a lot about United Airlines. The plaintiffs have tried to bring 31 individual defendants into this case. They haven't argued below or here as to how any of those individuals could possibly be liable, even if they could get over forfeiture and the problems with their claims against United. And so all claims against the individual defendants need to be affirmed. The claims that the plaintiffs relied on this morning, the EUA, as one of your honors mentioned, there's no private cause of action under the EUA. Even if you got over that problem, Legion courts have held that a private employer can't be held responsible under the EUA because it applies to those who administer the vaccine, and there's no allegation here that United was actually injecting anyone with vaccines. As your honors would be familiar, that this was a system where you'd go to a pharmacy or a doctor to receive the vaccine. As to the constitutional claims, they would need a Bivens cause of action. Everything you heard about state action today, again, waived, but even if it were all true and United were somehow transformed into an agent of the federal government, they need a cause of action to ground their constitutional claims, and that has to come from either an implied cause of action under Bivens or Section 1983. Under Section 1983, as the cases we cited, including from this circuit, as well as the Srirachi case in the Sixth Circuit held, all of their allegations are about the federal government, and this 1983 only applies to state governments. So that claim can't get off the ground. As to Bivens, I know, Your Honor, you had an argument yesterday about Bivens. Bivens has been recognized in the 8th Amendment, 4th Amendment, 5th Amendment. That's it. This is a very unusual case, which is obviously a new context under Bivens, and there hasn't been any serious argument as to why the court should recognize a cause of action. And I would submit that the constitutional claims on their merits also fail for two simple reasons. This court has already applied Jacobson to constitutional claims. That's the Klassen decision by Judge Easterbrook that we cited. As a matter of circuit precedent, the Seventh Circuit has held that Jacobson forecloses these COVID vaccine challenges. And even if you were prepared to go beyond that and try to determine whether there's some fundamental right implicit in substantive due process, Cruzan doesn't fit, because as you heard, Cruzan is about compulsory vaccination, my apologies, about compulsory medical treatment. In Cruzan, it was an end-of-life decision, and the question was someone who's incapacitated, can you force them to have food or water? Again, although the plaintiffs are claiming that this was sort of a compulsory medical treatment, it really wasn't. It was simply a requirement to keep your job. And so, again, it's a very different context. This is a COVID requirement at work, and if you didn't meet the requirement, there'd be job-related consequences, but there was no one actually forcing vaccination.
Let me ask you a procedure question. Did, from your perspective, the district court sua sponte dismiss the case?
No, I think it's important to address what happened here. So the district court, Judge Kennelly, really bent over backwards for these plaintiffs. So first, we removed from state court. United filed a motion to dismiss. The plaintiffs asked for additional time to file their response to the motion to dismiss.
We're aware of the procedural history. We followed it. I'm asking, did the district court sua sponte dismiss the case?
No,
or do you see it as pursuant to, you hadn't filed a second motion. You had a request in one of your responses that the court dismiss the case, but there was no new motion to dismiss.
Yes, both parties acquiesced. Judge Kennelly called both parties to a telephonic conference in the way the judge suggested to proceed, and that's why I was describing the posture. United's motion to dismiss was out there. I agree, that wasn't granted, but what the district court said is plaintiffs have come forward with an untimely an untimely complaint. They didn't file their opposition to United's motion to dismiss on the timeline, and they submitted a complaint which was just out of time and didn't follow the rules. So what Judge Kennelly said is, I will convert that into a motion for leave, and then he went through 2 rounds of that. So he entered a decision that was 20 pages long that said, here are the reasons why you don't state a claim, and then said, if the plaintiffs do not file a legally sufficient claim next, I will dismiss the case with prejudice. So the plaintiffs knew that. Again, I can represent to the court because I attended them. We had telephonic conferences with plaintiffs' counsel. There was never an objection to this way of proceeding. I think it was eminently fair because the plaintiffs had, again, the benefit of United's dismissal motion.
So the answer yes? Did the district court sua sponte dismiss the case?
I guess in a manner of speaking, yes. Your Honor, what the court determined was, I think probably the most precise way to describe what the district court said is, he would not grant them leave to amend because neither of the proposed complaints stated a claim for relief. And so because there was no case or complaint to be in front of the court, then the court said, well, I'm entering judgment for the defendants. Your Honors, we talked about exhaustion. Exhaustion, again, is an independent bar to all of the Title VII claims, and you haven't heard any substantial argument on the other side about that. I think the only argument that plaintiffs have made with respect to exhaustion is simply that the court should draft some sort of exception. Well, Congress has a very clear scheme. Exhaustion is required. Plaintiffs have admitted that not all their plaintiffs have gotten their right to sue letters. And again, they've had many, many opportunities to rectify that and have chosen not to. We'd also submit that the Title VII claims fail for the reasons that the district court gave. Unless there are other questions, Your Honor, we would request that the court affirm the judgment of dismissal.
We did not touch on the invasion of privacy argument. I believe that one might have been preserved and not forfeited regarding the face mask as well as the postcards?
Sure. Didn't address because plaintiffs hasn't raised it, but happy to. So there actually is a forfeiture issue
They
there.
did raise it in their.
No, I'm sorry. This
morning.
Right.
Okay.
So there is a forfeiture problem with that in that the plaintiffs did not respond to United's argument that the postcards themselves don't disclose any private fact. So the postcards at issue simply stated that you are an individual who has not yet uploaded your vaccination records. So that would equally apply to someone who was vaccinated but hadn't yet uploaded it, as well as someone who's unvaccinated. We made that argument. The plaintiffs have been crystal clear in their appellate brief that their only argument as to private fact is that vaccination status is a private fact. And so that claim can't get off the ground, both because it was forfeited below on that issue, but also because it's not a private fact. We'd also argue it fails on the publicity element. My submission is not until their reply brief on appeal, which I think is waived, did they make this argument that fellow employees fall into this special relationship and therefore are grounds to proceed. If I could just finish my thought. Thank you, Your Honor. However, I would direct the court to the Court versus Chicago Tribune case, which we cited, and is cited at plaintiff's brief, page 23, and the Carricker versus Rent-A-Center case from the Seventh Circuit that's cited at the appendix 121. Those cases clearly say that individuals who have a natural and proper interest to receive information can't be subject to the special relationship exception. So in other words, if an employee at United needs to know whether someone has uploaded their records, disclosing to that individual is not a public disclosure.
Okay, thank you, Mr. Malgeri.
Thank you, Your Honor.
Mr. Green, you had 42 seconds. We'll give you, we were asking you some questions at the end there, so 2 minutes.
I appreciate it. Thank you, Your Honor. Starting with the Bivens claim and talking about Jacobson and Cruzon as they just mentioned before, it's not only case law that states the principle that you have a fundamental right of the right of refusal, the right to say no when you don't want a medical treatment. The option to accept or refuse is codified, as we talk about in 21 U.S.C., and the same principle of right of refusal is also embodied in the Code of Federal Regulations. Title 21 of the Code of Federal Regulations reserves an entire chapter on the protection of human beings. So let's be clear, as much as United is saying that it wasn't a compulsory program, it wasn't a forfeiture of $5 as Jacobson was. That's not compulsory. What's compulsory is get the vaccine or lose your job, lose your entire employment. Some of my clients, ended up without their homes, had to forfeit their entire lives. Setting apart the voluntariness aspect, jurisdictions around the country, the 6th, the 9th, the 10th, the 11th, have begun recognizing exemptions from COVID vaccines and the vaccine mandate programs. There is no greater antithesis to reasonable accommodations than either getting the vaccine or losing your entire jobs. Touching upon in the last minute the invasion of privacy that opposing counsel had just discussed, we do believe, in fact, that there was an invasion of privacy with such delicate details, such as one's vaccination status. We start this discussion on page 27 of our reply brief that private information does not need to be absolutely secret to be protected. Medical records and medical information is confidential. To access one's medical records from a doctor or facility, there are protocols that confirms one's identity. You have to sign off on consent sheets and authorization forms.
Do you disagree with the connotation, though, or the representation by counsel on the other side that the information that was focused on by you in the opening brief was on vaccination status?
So I do agree with opposing counsel on that fact, and we do concede, as we talked about in our reply brief, that the second amended complaint does not substantively change anything from the first amended complaint. However, our position here is that we did not need to change anything substantively because there are multiple, not just one, claims for relief, which we have well pleaded. In finding vaccination status, they're trying to undermine how confidential.
Thank you, counsel.
Pardon me?
Thank you.
Thank you.
All right, well, we thank both attorneys, and we will take the case under advisement. We arrive at our fifth case for the morning, Garcia versus Department of Homeland Security, appeal number 24-1887. And it looks like Mr. Mungo has arrived remotely. Mr. Mungo, can you hear us well?
I can.
Okay.
And good morning, Your Honors.
You may begin when you're ready.
Okay, thank you very much. So, Your Honors, this case is a case in which the wrong standard was applied in dismissal of a race discrimination count in a 3-count complaint, which contained a count of retaliation and hostile environment. The hostile environment was the only count that went to trial. And I know that you've read the briefs, and I just want to point out some facts that I think is significant, because we did not reply to the appellee's response. And that would be, there is an assertion by both the court, the district court, as well as the defendants, that somehow we waived our argument and failed to address facts and legal arguments regarding certain events that took place that we believe constituted both discrete acts as well as acts that would fit in the category of the creation of a hostile environment. And that's simply not true. And I would just, for the record, reference the court to a docket 38, and which is plaintiff's response to defendant's rule 56.1 statement of undisputed facts, and then plaintiff's additional facts. And also docket 39, which would be plaintiff's memorandum brief in response to the defendant's motion for summary judgment. And in those documents, and I can be even a little bit more specific in terms of some of the paragraphs that some of these, well, I think just for purposes of defendant's docket number 39, plaintiff's exhibit 1, which we provide plaintiff's excerpts from plaintiff's deposition transcript, which itemizes and details a lot of the facts supporting the plaintiff's claims of discrimination based upon those acts. And the argument was that we didn't address it. And we obviously did. And therein, the cites to the record that I just gave you is evidence of that. And we would like the court to certainly take that under consideration. Other than that, fundamentally, the court, the district court, just used the wrong standards in light of Muldrow. And the defendants argue that there are 3 main categories upon which an adverse action can be established or must be established. And they limited plaintiff appellate to the second category, which states that there has to be some sort of transfer similar to—
Mr. Mungo, I'm going to jump in here. Let's just assume that we buy your argument that the evaluation scores do constitute some harm. Where is the record evidence that those scores were based on an impermissible animus?
Well, it's the only evidence that we have is, of course, the copies of the evaluations are in the record, but plaintiff testified, I think, in great detail about his conversation with his supervisor, who explained to him how he went about constructing and putting the evaluation, performance evaluation together, which varied from the standards and the practices that were followed by the agency. And of
Was
course,
that,
this
but is there any record evidence that this particular supervisor used that method only for your client, or did he just do his own thing with everybody? Where is the comparator evidence? You necessarily don't need comparative evidence anymore under Ortiz, but I'm just looking for anything in the record that shows that these scores from this supervisor was based on national origin. Because I don't see it, frankly, Mr. Mungo.
Well, it's not just that, Your Honor, but it's also the interference or the refusal to allow the appellant to secure career-enhancing assignments that would inure to the appellant being able to build a record that would justify getting higher scores. Now, the record shows that his scores were higher, but he never broke that threshold. And this is significant because that 1 point or 0.1 digit made the difference between him getting more money. And this was the practice. And the plaintiff testified that he was lied to by his supervisor about how to go about securing those opportunities. And then the very important point is that there's a direct relationship. The Snyder who belittled using plaintiff's national heritage in the presence of 3 of his work colleagues, going on with the Hey Vato. You remind me of the movie where this Mexican was deported, et cetera, et cetera. They were close. His supervisor and this same other supervisor who engaged in this discriminatory conduct and are close friends, and their offices are right next door to each other. And there's this undercurrent here of a continuation of disparate, marginalized treatment coming from these 2 individuals. And really, it blossomed on that one day just before an international mission in which this person just ran my client into the ground. And even his associates that were there, the 3 others were there. They had to leave and put their head down. I mean, that's how. So that's how we relate. And of course,
I'm sorry, Mr. Bill, I'd like to jump in before you get into your rebuttal time. But what event? It's just not clear from the briefing. What event forms the basis of the adverse employment action element of Garcia's discrimination claim? What event are you relying on?
Absolutely. The discrimination claim, that can be found in docket 43, page 12, where the district judge says she lays out the basis of the discrimination claim. The plaintiff was deprived of an opportunity to receive greater financial compensation due to low scoring on performance evaluations, and prevented from opportunities for assignments that would help him to increase his score by serving as a mentor and as a lead on different missions.
So I just want to make sure that those are your 2 that you're asserting for purposes of appeal, is the performance review scores as well as the lack of mentorship opportunities?
Yes, Your Honor. As well, we're looking at, and the ABA today is meeting, and they're covering all of the cases of Muldrow. Muldrow throughout many more circuits, and we have a more recent one out of the Southern District of New York, I believe.
I'm
the
sorry.
Anderson case.
I want to link up using those two. Going back to Judge Maldonado's question, what is the harm that we're alleging was suffered as a result of the performance review scores, as well as the lack of mentorship opportunities? Is there a link between the two?
So the link would be that both of those opportunities are tied to plaintiff appellant's ability to earn more money, to get the.
And so what evidence from the record? What evidence from the record? I know that's his argument, but what evidence from the record supports that? That if he had been given mentorship opportunities, or if he had gotten higher scores on those performance reviews, that he would have resulted in higher pay?
Well, that's built into those performance evaluations where, and there were also documents that indicated what, if you performed at a certain level, this is what your bonus would be. So the score is tied to making the money. And that's why he always kept him just below that threshold where he could make more money. And this is important, obviously, as this is how these federal air marshals put their life on the line all the time, make their money. So
thank you,
and they're living.
Mr. Mungo. You've used all of your rebuttal time, but we'll give you a minute when you return.
Thank you.
Thank you. We welcome Mr. Klaus to the podium, or Klaus.
May it please the court, counsel. We pointed out numerous deficiencies in the plaintiff appellate's brief: undeveloped arguments, forfeited arguments, lack of citations. To reverse the district court would mean adopting arguments appellate did not develop, relying on evidence he does not cite and indeed does not have. Taking a look at the district court's decision on summary judgment.
Can we just pick up right where we left off on the two adverse employment actions, now that we've drilled down that there's two, the performance reviews as well as the mentorship opportunities? What we've heard from counsel this morning is that those two opportunities limited his ability to get higher pay. Is there anything in the record that supports that argument?
There is not, Your Honor, and at a preliminary level, starting with the mentorship opportunities.
Yes.
Those are among a sort of category of alleged adverse employment actions that occurred in the year 2020 and beyond. So the incident itself occurred in 2018. The mentorship opportunity that he complained about was in September 2021. So it's a matter of 3 years later. We argued at summary judgment that that claim had been forfeited. It had not been exhausted. And the district court agreed it had not been exhausted. And the plaintiff did not address our argument regarding exhaustion. So the district court adopted our argument, not exhausted, and it was not raised in his appellate brief either. So that can easily be dismissed, setting aside the fact that there's actually no record evidence other than Mr. Garcia's testimony that securing these mentorship opportunities would have had any effect on his pay. In terms of the performance reviews, the district court again articulated quite clearly why those do not, quote, count as adverse employment actions. And there were two reasons. The first is that the scores are objectively high. I mean, he was receiving good scores before the incident. He was receiving good scores after the incident. In fact, his scores have improved. He's doing a good job as a federal air marshal. There are instances, said the district court, in which a plaintiff could argue, yes, I had good scores, but they should have been higher. But you need evidence to support that. You need admissible evidence. And all Mr. Garcia offered was his own opinion testimony. And the court spelled out on, it's the short record on appeal at 27 and 28, what sorts of evidence Mr. Garcia could have marshaled but failed to do so. Documents or authoritative testimony regarding TSA evaluation policies, none. Documents or testimony regarding Mr. Gengler, that was his supervisor, his evaluation matrix, none. Paperwork associated with Mr. Garcia's evaluations, none. Paperwork regarding evaluations of similar situated employees. He offered none of that, despite, in the court's words, its presumptive availability to Mr. Garcia during the discovery process. So, all he's left with is his own opinion, which is not uncommon among any employee, that his evaluation scores should have been higher. One more thing about the evaluation scores. When asked at this deposition which scores he thinks should have been higher, the answer was all of them. Every single one from 2 years before the incident to years after the incident. So the gripe concerning evaluation scores has nothing to do with this event. It's this long-standing gripe that he should be getting higher scores than he has. If I could address barring any further questions on those, if I could address Muldrow just for a moment. It was not clear in the brief whether or not Mr. Garcia was arguing that Muldrow affected the standard for proving a hostile work environment claim. To the extent he is arguing that, and again, I'm still not clear, there has not been a single case since Muldrow that has held that the severe and pervasive requirement for showing a hostile work environment has
Severe
changed.
Severe or,
correct.
Yeah.
And so the district court in this case noted that this is not a pervasive work environment case. It's just not. There was an incident, there was the single incident, and then there was a text message apologizing. And any other gripes or potential adverse employment actions that Mr. Garcia cited were either time barred or did not rise to the level of an adverse employment action. So this is not a pervasive case. This is a severe case. And this court, the Seventh Circuit, back in April, considering Muldrow in the Phillips versus Baxter case, reiterated that to support a hostile work environment case, conduct must be objectionably offensive and severe or pervasive to be actionable. This is the precise claim that went to trial, and the jury found that there was no hostile work environment. In terms of the pretrial rulings, which were the second issue raised in the appellant's brief, plainly there's no abuse of discretion here. The district court carefully spelled out its reasoning, and not only was it not abuse of discretion, it was correct to exclude the evidence that we asked to be excluded. So unless the court has further questions, we ask that you affirm both the district court's summary judgment rulings and its pretrial rulings.
All right, thank you, Mr. Klaus. Mr. Mungo, we'll give you 1 minute.
Thank you, Judge. So the docket 43, page 14, second paragraph, spells out in detail the plaintiff's deposition testimony in which he explains and articulates what was his investigation into the method and the system of putting the performance evaluations together. As well, docket 38 and docket 39 is just replete with references to transcripts and other documents that support plaintiff's claims that counsel just indicated that we did not provide any evidentiary support for. Testimony is evidence. And that, because that count was dismissed, and we believe it had a spillover effect on a no cause of our hostile environment claim by the jury. And on the issue of the claims allegedly that we waived, these incidents are incidents that we argued that grew out of the administrative charges. And all of these, well, most of them, if not all of them, grew out of the administrative charges. And Reynolds versus Tangralini, 737 Fed 3rd, 1093, 1099 through 1100, 7th Circuit, 2013, says if a claim satisfies this requirement that it's like or reasonably related to the administrative charge, that it's totally appropriate to add those.
All right, Mr. Mungo.
Mojo is being
Mr.
adopted by
Mungo.
Yes.
You're at the end of the time. You may finish your thought.
Okay. Just simply saying that Modro makes no mistake or produces no doubt that that lesser standard grows out of the plain language of Title VII. And it is applicable to hostile environment claims as well. And we have a case of McNeil out of the Sixth Circuit, which was decided in September of 2024, long after the case that counsel cited in the Seventh Circuit there. And I believe that all the circuits are ultimately going to wind up on the same side of the bank as the Sixth Circuit and a number of other circuits who have adopted and expanded the category of finding adverse actions, expanding that and lessening the burden on plaintiffs to prove adverse actions.
Thank you, Mr. Mungo. We thank both parties, and we will take the case under advisement.
Thank you, Your Honor. Thank you very much.
And that brings us to our final case of the morning, appeal number 24-1212, Cellco Partnership versus Deer District in the city of Milwaukee. And Mr. Murphy, we welcome you to the podium.
Good morning, Your Honors, and may it please the court. My name is Dan Murphy. I represent Deer District LLC. Deer District asks this court to reverse the district court's decision ordering the city of Milwaukee to issue permits to Verizon so that Verizon can install utility poles and small cell devices in the plaza that Deer District...
I'm going to ask a very practical question.
Sure.
The city hasn't appealed.
Correct.
And the permits have been issued.
Correct.
And the cell poles are up and running. So what relief is Deer District seeking?
Invalidation of the permits, which will require Verizon to remove the poles.
And you think that you have standing to raise this claim?
Yes,
despite the city of Milwaukee's lack of an appeal here?
Yes, Your Honor. I guess let me take that in two different ways. To the extent Your Honor's looking to the preemption argument by Verizon, I can address that, or I can address the fact that we're merely trying to enforce our rights under the lease with the city. That was the reason that we intervened in the district court action. We asserted those rights there. We maintained then as now that they...
Right, but the TCA holding is there and...
Correct.
Yeah.
So there's no authority for the proposition that the TCA violation could trump private parties' property rights. And such a result is inconsistent with the purpose of the TCA. The TCA left the siting of small cells and utility poles for installation of small cells to the states. Wisconsin did that. It enacted section 660414, which clearly states that those poles may only be installed in rights of way. And under subsection 8 of that statute, it expressly says that private property cannot be the location of any small cells. And so the combination of those two, Your Honor, preserve our ability to enforce our rights under the lease, notwithstanding the city's failure to support its denial of the permit applications with substantial evidence, which was the only violation of the TCA that the district court found. So there's no substantive conflict between the violation of the TCA and our ability to enforce our rights under the lease. And I would also offer the hypothetical that we did in our briefing, Your Honor, that the result advocated by Verizon, the instance possible by your question, is that a city could mistakenly approve the installation of a small cell in a private residence. And if it only belatedly determines that that is what it did, that it mistook the location of the small cell, under Verizon's view, that would mean that there is no recourse for the private property owner. Again, that's inconsistent with the balance struck under the TCA. It's inconsistent with the text of 660414.
Let me add to Judge Maldonado's question. Why did Deer District not seek a stay pending appeal earlier in the litigation?
A number of reasons, Your Honor. I guess the most practical one is we believe that we do have standing to have them removed over time. We believe we've preserved our ability to pursue this relief at this point, which will address our broader concern, Your Honor, which is Verizon is, of course, not the only wireless provider. It's not the only utility provider. And if others seek to do what Verizon did in this case, that will not only erode and...
No, but why not address the issue at the moment the district court says the city can issue these permits? And the city has to do it immediately. Time's running out.
I guess, Your Honor, for the practical reason of we had filed an appeal and sought to pursue that process. I don't think that the installation of the poles had such an immediately disastrous effect to the property that there wasn't that concern. They can be removed. It's really preserving our rights under the lease. That's our main concern. And also to avoid the consequences of the district court's decision in interpreting section 660414 so broadly.
Okay. Now, you talked about inconsistencies earlier. So on that idea, we have Ogden in the Third Circuit, which cautions against allowing an in-run against the TCA, okay, by elevating zoning authority, this quote, zoning authority over congressional policy, end quote. And then you've got the Sixth Circuit in T-Mobile similarly saying it could affirm a violation of the TCA despite the presence of state laws. So tell us how this case is different from Ogden and T-Mobile.
Certainly. Ogden, so first of all, in both cases, it was an appeal by the municipality regarding the TCA violation, so that's one distinction, and that relates to the other distinctions, which are, in Ogden,
How does that distinction help you?
So that distinction helps me, Your Honor, because I'm not appealing the TCA violation. I'm not saying that the city provided substantial evidence, and I don't need to prove that to this court in order to prevail. What I need to show is that my client holds the rights to control commercial activity in the plaza, improvement of the plaza, and use of the plaza.
But the injunction was issued under the TCA, right, against the city. So what happens if we were to rule for you? I mean, I'm just not getting this from a procedural standpoint and from a standing issue. You know, the city chose not to join you in this appeal, and they're going to be bound by that injunction. You know, even if we were to rule for you on your property rights arguments. So it feels very advisory to me. So, and I'm concerned about standing and redressability of what you're asking us without the city of Milwaukee next to you.
So respectfully, Your Honor, the district court put the cart before the horse. Before the TCA could apply, it needed to find that the site proposed for the permit was a permissible location for the poles to be installed. That's the balance between the TCA and the state legislature's enactment of 660414. The district court didn't do that. It looked to the TCA, found a violation of the procedural requirements of the TCA, and I will discuss at some point the errors in the court's analysis of whether or not the plaza qualifies as a right-of-way. But to your point, and to the point about why Ogden and T-Mobile are inapplicable here, it's because we are not alleging that our property rights make it that the substantial evidence existed, right? We're not saying that, we're not arguing anyways, that the city did not violate the TCA. What we're saying is the TCA didn't apply because it is our property rights, our property rights make clear that this was never a site that could be developed for small cells.
Would the argument change if there was a finding that that the plaza is not a right-of-way? And I'm looking at that Wisconsin statute in particular, similar property, that this plaza would not qualify under that Wisconsin statute to be a right-of-way.
I want to make sure I understand your question. Are you saying would my argument be different if it was not a right of way?
Yes.
So I guess if the plaza is not, that is what I'm arguing. If the plaza is not a right of way, then the TCA doesn't apply. It's not a site available for small cell development. So the application for a permit there fails under that step before you even get into the question of whether the city appropriately evaluated.
That's what I was trying to give you a softball so we can move to the next issue.
Sure, I appreciate that, Your
regards
Honor.
to the right of way.
And I do want to reserve time for rebuttal, so I think I'll stop there.
Okay.
Thank you.
You're welcome. Mr. Ruck.
Good afternoon, Your Honors, and may it please the Court. My name is Jimmy Ruck, and I represent Cellco Partnership doing business as Verizon Wireless. The District Court's ruling that the city's permit denials violated the Communications Act, which the city did not appeal, and Deer District does not challenge on appeal, forecloses Deer District's arguments on appeal that the city lacked authority to grant its permits. The District Court properly found that this argument was untimely because it fell after the time frame that federal law mandates for a written decision. Now, if the city had
support for that,
sorry, Your Honor, what's
is
the
there any support?
The District Court acknowledged the federal regulation that says there's a 90-day shot clock, and so
I understand the shot clock ran. Is there any support for your argument this morning that would have allowed us not to be able to consider their argument that came after the shot clock?
Yes, Your Honor. So Deer District has no greater rights than the city when it comes to defending
What's your law that supports that proposition? That's my question.
Yes, Your Honor. So we point to the cases that have already been raised this morning, Ogden and T-Mobile, also the national case in the First Circuit. Those all are analogous cases, but they reject attempts to defend a permit denial on grounds that were not presented on a timely basis.
But those cases don't address untimeliness resulting from supplementing reasons, okay? So do you, does the FCC have other courts treated supplementation, like what's happened here, as constituting a missed deadline?
Your Honor, if I'm understanding what you mean by supplementing,
Here they added a reason. They added a third reason. The city added a third reason for.
So, Your Honor, I think if you actually look at the T-Mobile case, there were 5 issues that were brought in the denial, and then what happens afterwards is the township gives a separate one saying that the specific Michigan zoning law gave the township board a great deal of discretion in considering this permit. So that's what I would say that's similar to what you're saying. It was supplemental. It wasn't found in the initial permit basis, but on appeal, the township tried to use this supplemental basis. And so the Sixth Circuit rejected it and said that it needed to look at what was timely and what were the stated reasons in the initial denial. So regardless of this whole argument about that Deer District's foreclosed from raising the argument that the city lacked the authority to grant the permits, I also believe that the district court correctly found that the public plaza has always been and remains a right-of-way in which the city had the authority to grant small cell permits. It's undisputed that at the time of the lease, the public plaza was a right-of-way. During the trial, both sides, both the city and Deer District, admitted this fact. And so therefore the burden is on Deer District to show that the lease changed the nature of the public plaza.
Let's look at that lease, E2 in particular, where E2, dealing with utilities, if we accept the proposition that these were utilities, WCD acknowledged here, Deer, that the owners of the utility facilities could come on to that property for repairs and replacement. And so where within this language were your clients permitted to come on and put up new small cell poles?
So, Your Honor, several things that I would point to. First off, the lease repeatedly, and that's in the recital section C in 4E1, and I'll read these out. It repeatedly affirms that this is a right-of-way. So it's a public right-of-way, And this court should start from the premise that the city, which has police powers, the Seventh Circuit has recognized, and the Supreme Court has recognized that one of the core police powers is the regulation of utilities. So this is a public right-of-way, and the city has zoning authority, and one of the key aspects of that is the right to grant or deny these type of utility permits. So the city has that existing authority. This is a public right-of-way. Section 4C says, recital section C says the city holds the right-of-way known as the 4th Street Pedestrian Mall. 4E1 says this is the WCD acknowledges that the city holds this pedestrian mall as a public right-of-way. I also would point you to Section 17A of the lease, which my friend on the other side doesn't actually, I think, raise or address in the reply brief. And again, it says that because the city holds this public plaza as a public right-of-way, the premises are property tax exempt. And then the final point I think that I'd really draw this court's attention to is Section 15B of the lease. And this is a very broad granting or acknowledgement that the city has the authority to grant permits here. So in 15B, it's titled encumbrances.
Is a suggestion then where you're headed, that this language in the contract, the city wasn't permitted to even do, basically giving away their power? Is that where you're headed?
That's an independent basis. We do touch upon that on our brief.
And so can I redirect you then back to my question? What do we do with this language in E2? You've moved on to police powers, but I want you to answer my question.
Your Honor, so E2, all that it's doing there is just acknowledging existing utility owners' right to be able to access the facilities. It's not granting any new rights there. It has no impact on the city's existing authority to grant or deny permits. And so that's the only function of 4E2. And that's why I think 15B really codifies that understanding, because it says the city retains the right to devote portions of these premises for utilities, as described herein. And then the other part of the language, which is very powerful, is the city also retains the right to devote portions of the premises for other easements necessary for the public welfare and convenience. And that is that catch-all phrase, I think, that clearly just reaffirms that the city had the existing authority to grant or deny permits, and nothing in the lease took that authority away.
Did you already address Wisconsin's small wireless facility statute, section 66? So what if we disagree with you and we find that under that statute the plaza is not a right-of-way? What authority can you point to that the city had to grant the permit?
So, Your Honor, I'll address your specific question and then add some more points. So if you disagree with that the pedestrian mall is a right-of-way under that small cell statute, which we disagree with, you would then turn to the argument that the city cannot contract away its police powers. So that's addressed in our brief. But both the Supreme Court and the Seventh Circuit have just recognized that granting of utilities is a core police power. The city can't contract away that specific right. And I would also just say that when you look at Section 332 of the Communications Act, it contemplates local and state governments engaged in the review of siting applications. It doesn't say anything about private parties. I also would say that the small cell statute, Your Honor, similarly is addressing local and state actors, government actors, providing review of these small cell facilities. So it has nothing, it's not even contemplating the possibility that a private entity like your district would have the authority to grant or deny permits. But Your Honor, I also wanted to say that we think we believe that the other similar property language that the district court found that was a catch-all clearly encompasses the pedestrian mall, the public plaza in this case. Both the pedestrian mall, the definition in Wisconsin law is that it's any street or land for the enjoyment of pedestrians. The sidewalks in Wisconsin law are defined as an area constructed for use of pedestrians. Other similar property is a broad phrase. It doesn't mean identical. And I also think that it's important to note here, Your Honor, that the small cell statute, its purpose was to facilitate issuance of small cell permits by establishing a consistent and efficient application and permit process, because the legislature wanted to facilitate the rollout of small cell technology for higher speed connectivity. And I can't think of really a better place than this public plaza for why the legislature would have wanted these types of small cell facilities. So the district court, after its trial and hearing testimony from witnesses, in its fact of finding stated that when the Milwaukee Bucks were in the NBA championship several years ago, a bunch of Verizon subscribers, including law enforcement and first responders, experienced connectivity issues. And that's in Supplemental Appendix 53. The legislature enacted the statute to ensure that there was going to be better connectivity for the greater public. And so this is the exact type of place that falls neatly within the other similar property language within the small cell statute, Your Honor. I would just want to end with the final point that the district can't point to a single point or aspect of the lease whereby the city actually contracted away its authority to issue permits for small wireless facilities, because that's just an existing right that it had. And it's undisputed that the public plaza is a right-of-way. Nothing in the lease changes that, and the small cell statute did not impact that existing characteristic of the public plaza. If there are no further questions, thank you.
Thank you, Mr. Rock. Okay, Mr. Murphy, you've got your rebuttal time left, and you can do well with that.
Thank you. So I want to start where Verizon just ended. That's accurate. The city did not convey a permitting authority to the Deer District, and that's why the police powers doctrine is totally inapplicable here. It conveyed a parcel of property via a leasehold to a private party, something municipalities do all of the time. As a consequence, it lost the ability to permit that area, but that doesn't mean that it was conveyed to Deer District. So police powers do not apply. The references to right-of-way in the lease are true. The Deer District Plaza is open to the public. That is the common law sense of a right-of-way, not the sense defined in 660414. Turning to the provisions that opposing counsel cited regarding encumbrances, I thought I would read for the court the end of that provision, that the rights reserved to the city in that provision may not unreasonably interfere with Deer District's rights under the lease, WCD, which Deer District stepped into WCD's shoes. So there are no provisions in the lease. The other provision cited, 17A, is regarding property tax exemptions. It says nothing about installing additional utilities in the plaza. The references to right-of-way in the lease do not demonstrate that the plaza is a right-of-way for purposes of 660414. The enumerated examples in 660414 are nothing like a privately controlled pedestrian mall. The legislature knows what a pedestrian mall is. If it wanted to allow Verizon to install small cells in that area, it could have done so. It didn't. Thank you, Your Honors.
All right. Well, thank you to both parties. We'll take the case under advisement. And that concludes our session this morning.